The Chief Justice and His Excellency President Ramaphosa have already observed protocol. You will therefore agree with me that there has been substantial compliance, and therefore it will not be necessary for the other speakers to do so. I think it's correct if I say condonation is granted in that respect. Before we proceed with the presentation from the international guests, there are two videos that we are going to watch. The one will be from the Speaker of Parliament that should have been presented earlier this morning, and then thereafter it will be the one that will be presented on behalf of the President of the African Court. May the technician assist us with the video, the first one on behalf of the Speaker. Thank you.
Your Excellency President of the Republic of South Africa, President Cyril Ramaphosa, Chief Justice Mandisa Maya, Acting Deputy Chief Justice Mbuyiseni Dlamini, Justices in the Constitutional Court, members of the Judiciary, Chairperson of the National Council of Provinces, Ms. Refilwe Mtsweni-Tsipane, distinguished guests, ladies and gentlemen. It is my utmost honor and privilege to join this esteemed gathering of jurists and distinguished guests in commemorating the 30th anniversary of the establishment of the Constitutional Court, the apex court of the Republic of South Africa. It is unfortunate that I'm not there with you in person because of other pressing needs of the legislature. However, I'm happy that I'm able to talk to you through video link. By their very nature, constitutions and the courts that guard them are crafted to be transformational. Around the world, constitutional courts have served as bridges from colonial rule to independence, or from oppressive regimes to new orders of freedom and democracy, as is the case with South Africa. In 1994, the Constitutional Court was established under fragile circumstances, with the deep scars of apartheid and segregation still visible across our society. It emerged amidst fears and uncertainty at the dawn of our democratic dispensation. The founding judges of the court were tasked with an extraordinary responsibility to breathe new life and hope into a divided society, to embody and uphold social and economic justice, and to lay the foundations for constitutional democracy rooted in the comprehensive rights enshrined in the Bill of Rights. From its inception, it was essential that the court reflects the diversity of South Africa. Representation in terms of gender, race, and lived experience was not merely symbolic, it was essential. This inclusivity enriched the court's capacity to deliver justice from multiple perspectives and to ground its jurisprudence in the real lived experiences of all South Africans. Over the past 3 decades, the Constitutional Court has played a central role in entrenching our constitutional democracy and safeguarding fundamental human rights. It has helped shape a participatory democracy grounded in the rule of law and social justice. Particularly in the past decades, our courts have risen to meet the growing expectations of society, transforming criticism into courage and public skepticism into legitimacy. In doing so, they've earned their place as the final arbiters of constitutionality in our republic. Of course, with such authority comes great responsibility, the duty to assess and affirm the constitutionality of laws and execute actions often leads to tensions amongst 3 arms of state. Yet this duty is critical, and the authority of the courts must be protected and respected by all South Africans. Equally, judicial office must be reserved for individuals of highest integrity and impartiality, men and women beyond reproach. To serve on the bench demands an extraordinary combination of intelligence, wisdom, composure, courage, and a deep historical consciousness. Our judges must be sensitive to our painful past while being obsessed with a future rooted in dignity, justice, and the rule of law. In the past 30 years, the Constitutional Court has delivered landmark judgments that have reshaped our society. It abolished the death penalty, protected gender equality, and upheld the rights to vote for prisoners, affirming dignity and freedom for all. In its second and third decades, the court provided clarity on the separation of powers, particularly in strengthening Parliament's oversight role and ensuring the executive remains accountable. Through its jurisprudence, the court has not only interpreted the law, but elevated our constitutional values, fostering a deeper public understanding of our democracy. Our Constitution assigns Parliament the responsibility of lawmaking and oversight, with public participation at its core. Simultaneously, it vests judicial authority in the courts. While these branches of state are distinct and independent, they are also interdependent and must support one another in service of the people. At key moments, the Constitution mandates collaboration between Parliament and the judiciary, such as during the first sitting of the National Assembly and the National Council of Provinces after election, where Chief Justice or their designee presides over the swearing in of new members and also the election of the presiding officer and thereby the president. Parliament also participates in judicial appointments and accountability through the Judicial Services Commission. The courts, in turn, safeguard constitutional compliance in legislation and executive action. These are built-in checks and balances designed to ensure a healthy, functioning democracy. However, in recent years, we've observed a growing number of political matters and constitutional questions being decided by the court, some of which traditionally fall within Parliament's domain. This is not criticism, but rather an observation of the growing overlap between our roles at times. It is clear that this rate necessitates better collaboration in the judiciary. Just as Parliament benefits from the leader of government business to facilitate its relationship with the executive, perhaps the time has come to consider a mechanism to facilitate regular structured engagement between Parliament and the judiciary, a neutral platform for reflection, dialogue, and coordination on matters of constitutional importance. As we mark this historic milestone, we acknowledge that the first decade of the Constitutional Court was pivotal in addressing social injustices and protecting human rights. The decades that followed deepened our understanding of the separation of powers, curbed excesses of executive authority, and reinforced the critical oversight function of Parliament. Looking at the next 30 years, the judiciary must remain committed to the transformative vision of our Constitution, particularly in developing the common law to advance both social and economic justice. In this second Parliament, we have already begun an intensive engagement with Chapter 9 institutions to assess how their mandates are being implemented in advancing our constitutional project. I'm confident that closer collaboration with the judiciary will enable all our democratic institutions to better fulfill their mandates and contribute meaningfully to the realization of a just, equal, and democratic society. I thank you.
Chairperson of the NCOP and the Deputy Speaker, kindly convey our sincere gratitude
His Excellency
to the Speaker for the presentation. Thank you. The next presentation is going to be done. It's on behalf of the President of the African Court on Human Rights and Peoples. It's done by Honorable Lady Justice B. Chafika. Thank you.
See President Cyril Ramaphosa, President of the Republic of South Africa, Honorable Ms. Thoko Didiza, Speaker of the National Assembly of South Africa, Honorable Justice Mandiza Maya, Chief Justice of the Republic of South Africa, Honorable Mboloko Kubayi, Minister of Justice and Constitutional Development, Honorable Justice Luke Malaba, Chief Justice, President of the Conference of Constitutional Jurisdiction of Africa, Honorable Justice Lala, Chief Justice of the Kingdom of Eswatini, Honorable Justice Kelo Getse, Chief Justice of Botswana, Honorable Justice Shivute, Chief Justice of Namibia, Honorable Justice Kekere Ekun, Chief Justice of Nigeria, Honorable Justice Richard Wagner, Chief Justice of Canada, Honorable Justice Justice Mbuyizelo Madlanga, Acting Deputy Chief Justice, Honorable Justice Fahmi Iskandar Boulos, President of the Supreme Constitutional Court of Egypt, Honorable President Ribeiro, President of the Constitutional Council of Mozambique, Honorable Justice Mittal, Supreme Court of India, Honorable Justice Lenaula, Supreme Court of Kenya, ladies and gentlemen, all protocol observed. On behalf of the President and all judges of the African Court on Human and People's Rights, I would like, in my capacity as Vice President of the African Court, to thank you for inviting the African Court to make a speech to this very important event, the 30th anniversary of the establishment of the South African Constitutional Court. Regional integration has many components. This is particularly true when we focus on the African Union Constitutive Act, whose drafters have insisted on the integration agenda. Among others, the objectives of the African Union are to accelerate the political and socio-economic integration of the continent and to promote sustainable development at the economic, social and cultural levels, as well as the integration of African economies. It's worth reminding, as indicated at the beginning, that regional integration has several components. However, it's important to flag that the judiciary plays a very important role in consolidating regional integration by many ways. Resolving disputes or issuing advisory opinion through interpretation of treaties, including human rights treaties on human and people's rights, plays a crucial role in consolidating regional integration in Africa through its mandate, as well as through judicial diplomacy. Regional integration through the mandate of the Court. The African Court performs its mandate on two aspects: contentious jurisdiction and advisory jurisdiction. The contentious jurisdiction of the Court consists on certain mandate of the Commission as provided by Article 2 of the Protocol. Moreover, following Article 3 of the Protocol, the jurisdiction of the Court shall extend to all cases and disputes submitted to it concerning the interpretation and the application of the Charter, the Protocol, and any other relevant human rights instrument ratified by the state concerned. The courts can be seized by the Commission or a state party. Individual and NGOs having observer status before the Banjul Commission can file application if the state concerned has made the declaration accepting the competence of the court under Article 34 sub 6 of the Protocol. To date, 12 states have made such a declaration, but 5 of them have withdrawn the same, which means that currently individuals and NGOs having observers
Seems as if that's it. Thank you. We are indebted to Lady Justice, Lady President, and Vice President Justice, the Chafrika, for the message. I'm just going to remind the speakers on the stage that condemnation has already been granted. Protocol has been observed. So we will just proceed with their presentation. The first speaker on my list will be the President of the Conference of Constitutional Jurisdictions of Africa. We normally call it the CCJA. That is the Honorable Chief Justice Luke Malaba, who is the Chief Justice of Zimbabwe. Ladies and gentlemen, may you assist the Chief Justice to the stage.
Thank you very much, Madam Director, the Chief Justice Mandisa Maya, the Deputy Chief Justice of South Africa, all the participants here present, ladies and gentlemen. I stand before you as one of those who believe in the transformation of the wishes, the aspirations of the African people. It doesn't matter what status or position of that African is. Neither does it matter what color, origin, nationality of that person. The fact that that person is a person, is a human being with the values, the principles of law to enjoy and be protected by. That is my dream. That is the kind of renaissance this man spoke about. That we must proceed as a body of the faithful. We must proceed as a body of the faithful to transform the values of the lives of these people we call Africans. That is the dream that those who fought for independence, for freedom, for equality, for the rule of law, for the independence and the impartiality of the judiciary, embodied in what we call, in glossy, beautiful words, constitutions. Glossy, beautiful words that we profoundly pronounce every day. They embodied those dreams because those dreams relate to people. They relate to the social, economic conditions of the majority of our people. They relate to the grinding poverty They relate to the elitist abuse of power. They relate to the corruption that has become characteristic of the post-independence of our continent. So, the question really is, what is the role of the judiciary? In this context of unplanned development, that was not the wish of the makers of the constitutions. The wishes, the aspirations of the makers of constitution was to develop societies that are equitable, societies that enforce, believe in, and substantively produce equality, no matter at what level of that socio-economic position. Equality, freedom, the rule of law, where everybody is equal before the law. Those are the ideals of independence. These are the ideals of tomorrow. These are the ideals of today. These are the ideals of always. That is why we embodied them in these sacred documents, the living documents of law, to control every one of us, no matter what position we are in, including the judges themselves, must act in terms of the law. No one is above the law. Those are the basis of the legal relations embodied in these constitutions. Those are the basis of the legal relations that constitutional courts and constitutional judges, or judges everywhere, have a duty to enforce. That is our responsibility. That is why we have the independence. That is why we have this independence guaranteed, so that we can do our job without fear, favor. But is that what is happening? I speak to you as a president of the constitutional jurisdictions of Africa. Madam Chief Justice, the constitutional jurisdiction of Africa is a product of the decision of the heads of state, of member states of the African Union. Is born out of that realization of the gravity of the situation, of the need to uphold and live under the fundamental principles and values of constitutions, where human dignity is the foundation of everything, where no more again will there be apartheid. That is the kind of responsibility entrusted upon each and every member of government in Africa. No more again should we have economic power entrusted in individuals who have no commitment to the values of the Constitution, where the economic power is relying on purely the individual choice, the right to choose to be rich and be as rich as you want, regardless of the effects on the rest of others of that exercise. We don't say in Africa that there should be no exertion of the self. We don't say that there should be no enterprise. That's not what we say in Africa. We welcome enterprise. Because the very fact of improving lives of the people, there must be economic development. You cannot talk of improvement of the material conditions of existence without the economy, without the business, without business women and men. They must be there. But we say the business activity must be subjected to the fundamentals under which each one of us works. It must be subjected to the collective power. That is what our Constitution says. But we have lost it somewhere. We have lost it somewhere. Why do Africans continue to have a segment of the people suffering in poverty? Suffering in poverty, in a sea of plenty of resources. Are these fundamental questions only for politicians? No. These are fundamental questions of constitutional justice. These are the fundamental questions of constitutional justice. Who do we have in this court? What kind of courts do we have in Africa? How do these courts operate? How do their decisions get distributed? These are the questions we, in the Conference of the Constitutional Jurisdictions of Africa, are asking. And I'm happy we are celebrating today Madam Chief Justice. We're not just celebrating the establishment of this beautiful organization in your country, the Constitutional Court. We are celebrating the participation of gallant men and women in it, both in civil society. Those are the people who realize their obligation to mobilize, to create the public interest litigations that we're talking about, where all these landmark decisions came from. It was through action by them. And it is out of these landmark decisions that we, in this organization, realize the value. We realize the value of the African area. I want to emphasize. We realize the value of the African area of constitutional justice. That is what we stand for. We stand for upholding in this world the African area of constitutional justice. And it is there, in that belief, that we stand united and better by realizing the strength of a united, a common base of the constitutional justice of Africa. We stand stronger by realizing that. We cannot be strong if we remain segmented. That's why we are here. That's why I'm here, to participate in this demonstration, Madam Chief Justice, of the goodwill, the solidarity, because that is the basis of my organization. It's based on the realization of the need and the power of solidarity. And that should not only be solidarity of political actors. They are very important. They are drivers of policies. They are critical. But there is also checks and balances in our countries which must resonate as fundamental principles and values all over Africa. It is that we are fighting for. The commonality of the existence under the law. The commonality of the existence under the law. That is why the landmark judgments of the Constitutional Court of South Africa have been positively received in Africa. Positively received. Because they speak to the aspirations of Africans. They speak to the substantive changes that the African people want. They don't just speak to the form, the abstraction. They speak to the substantive rights. And that is where the value of the judgment of a court lie. They lie from that departure from the past, a clear break with the past, to transform and go into the future. That's why we always speak, and you speak through your judgment, of progressive realization. Progressive realization of socio-economic rights. That is your constitution. That is what my constitution says. But why progressive realization? Because that is a dream. That is a fundamental value. That is a fundamental principle by which we must transform our society. We must move into the future for today, tomorrow, and forever. Always. That's a fundamental principle. So we must then bear the burden of upholding the rule of law. Why? Because these fundamental values on which your constitution is standing, on which the decisions of the Constitutional Court of South Africa have been based up to now. These are universal values. They are not exceptional to South Africa. They are not exceptional to South Africa. Let's not cheat ourselves. They are fundamental values guaranteeing Ubuntu, guaranteeing the Africanness. These are the values and principles that guarantee human dignity. Human dignity is the source of all these human rights we talk about. It is the source. Every freedom of expression, it originates from human dignity. If political freedom of association originates from human dignity. Have the right to the resources, be free from poverty, it originates from human dignity. Because I'm human, I am the being. I must not be hungry like anyone else. The bottom line is, I should never be hungry and go without food, without clothing, without shelter, just because I just have no access to the resources, which are in the hands of a few, perhaps. That's monopoly. But that has nothing to do with monopoly has nothing to do with human dignity. It's dehumanizing. So we must change the fundamentals and understand. And that is why we celebrate today, Madam Chief Justice, your predecessors. They seem to have understood what I'm talking about. Transformation. Transform society. Transform the people. Transform the way of thinking. Even transform the judge. Because if we speak of a judge, we speak of a product of law. We speak of a creation of law. We speak of a person answering to public duty, to public office, to responsibility. We don't speak to a person answering to personal interest. That's corruption. That's corruption. Public office does not call for personal interest. It calls for duty. There's no right in a public office. There's no right in a public office. You must enforce the duties. I wish all the other branches of government understand what I'm talking about. Because if you don't, then that's when you begin to have elitist state capture. It comes from personal interest at the expense of the duty to uphold public interest. Anyway, I think I have overdone my time. Thank you very much for listening to me. I may say more and more and more, but the paper is here.
It's difficult to ask the Chief Justice to stop when he's still speaking. You have to show some respect. Thank you, Chief Justice, and thank you for the thought-provoking speech and for reminding us of our duties. And must applaud the CCJA members for the work that you are doing. Thank you very much. Our next speaker will talk about the two constitutions that bind us, and he will do a reflection on 30 years of judicial kinship. He is the Honorable Chief Justice Richard Wagner, who is the Chief Justice of Canada. You will have noticed that I don't do the introductions in terms of the bios. Those are available online. Thank you.
Well, thank you so much. Thank you also to Chief Justice Maya and the distinguished members of the Constitutional Court of South Africa for inviting me. It is a great honor to stand before you on the occasion of this remarkable milestone, the 30th anniversary of the South African Constitutional Court. As a fellow member of the global judicial community, I join with many others gathered here today to extend my deepest congratulations to you for this court's extraordinary work over the past 3 decades. The continued success of the South African Constitutional Court is a testament to your unwavering commitment to democracy, the rule of law, and the protection of fundamental human rights. It is truly a privilege for me and my spouse, Justice Catherine Mandeville, to be here with you to honor this momentous occasion. We visited for the first time last year for a judicial exchange between this court and the Supreme Court of Canada. I continue to recount to colleagues how deeply your insights and experience impressed me. This court has played an essential role not only in shaping the democratic landscape of South Africa, but also in influencing the broader international community, and for that, we are all grateful. In the world of constitutional law, few documents have as much significance and influence as the Constitution of South Africa. Its drafting was a groundbreaking moment in human history, marking the transition from oppressive era of apartheid to a new chapter of inclusivity, justice, and reconciliation. The Constitution enshrines values that resonate globally: human dignity, equality, freedom, and democracy. Of all the features of South Africa's Constitution, the preamble speaks to me the most. You know it better than I. We, the people of South Africa, it begins, recognize the injustices of our past. These are not words of convenience. They are words of conscience. They name what was done, and in naming it, they begin the work of repair. The preamble speaks of healing, unity, human rights, and freedoms. But it does so without turning away from the wounds of history. It is, in that sense, a declaration of moral clarity, one that few constitutions have dared to make so directly. I want to share something personal with you. I have your Constitution's preamble hanging in my office. It was a gift from Justice Albie Sachs from my visit last year. It serves as a reminder that our work for justice and equality is never done. These are not merely abstract goals, but rather values that must animate the decisions on our courts that courts are making every day. As a Canadian, I am proud of the modest role that our Charter of Rights and Freedoms has played in the development of your constitutional framework. Today, I would like to speak about a notable feature of both our Charter and your Constitution, the Limitation Clause. In Canada, Section 1 of the Charter provides that the rights it guarantees are subject only to, and I quote, such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society, end quote. The South African Constitution, Section 36, permits limitations only if they are reasonable and justifiable in an open and democratic society based on human dignity, equality, and freedom. Both of our legal traditions have adopted proportionality as the guiding principle for the application of these clauses. To me, our limitation clauses are notable because of their uniqueness on the world stage. Few other constitutions include such a clause, instead opting to guarantee rights in absolute terms. After all, why include a provision that permits the limitation of rights in the very same document that enshrines those rights? Does it not send the wrong message that rights are optional or easily set aside? Perhaps the South African drafters should have picked a different clause of ours to borrow. But the truth is that our two countries understand the wisdom of the limitation clause. We know that the limitation of rights is inevitable, whether it is acknowledged or not. In a society built on rules of general application, rights will intersect and they will conflict. When they do, public policy must embrace compromise. That is what it means to live in a complex, vibrant, and democratic society. What these clauses recognize is that even though the limitation of rights is unavoidable, the mode of limitation can be defined, constrained, and disciplined. That is our job as guardians of our constitutions. We oversee governmental power so that it curtails rights only when it is absolutely necessary to achieve a pressing, a substantial objective, done in the least impairing way possible, and proportionate to the government's salutary objectives. In this way, we ensure that governmental power remains subject to the rule of law. Justice Albie Sachs once said, and I quote again, "If I were to be stranded on a desert island and allowed to take only two constitutional elements with me, I would take human dignity and proportionality." In that simple image lies a profound truth. Dignity is the foundation of rights, but proportionality preserves them. It would have been easy for our constitutional drafters to simply say that rights are guaranteed without limits. Sounds nice, doesn't it? But it is an empty promise. What is much harder and far more important is guaranteeing that even when rights are limited, the rule of law never falters. Canadians are proud to share this unique constitutional feature with you and to develop this area of constitutional law alongside your court. I could go on about the elegant provisions that make up your Constitution, but my comments would be incomplete without discussing what your court has done to bring those provisions to life. Indeed, seeing echoes of our Charter in your Constitution is a source of pride. But seeing the courage, creativity, and principle with which you have built on your jurisprudence is a source of real admiration. While the South African Constitutional Court is still relatively young in its 30 years, it has developed jurisprudence that is both influential and deeply respected. Your court has become a model for courts globally, particularly in its approach to interpreting and upholding constitutional values. Few courts have so consistently placed dignity at the center of their reasoning, or shown such clarity in recognizing that legal text must ultimately serve the lives of real people, not abstract ideals. When our court was faced with the important question of whether prisoners should have the right to vote, we drew on the wisdom of your words in August against South Africa, and I quote, "The vote of each and every citizen is a badge of dignity and of personhood." Quite literally, it says that everybody counts, end quote. When grappling with the difficult concept of impartiality, our court leaned on your idea in Irvin and Johnson Limited, that judicial impartiality is the keystone of a civilized system of adjudication. When we were asked whether it is constitutional to extradite individuals who may face the death penalty, we turned to Justice Chaskalson's profound maxim in Makwalania, and I quote again, "It is only if there is a willingness to protect the worst and weakest amongst us that all of us can be secure that our own rights will be protected," end quote. It reminds me of our court's recent decision in Bissonnette, where we struck down a provision allowing courts to stack parole ineligibility periods to keep offenders incarcerated without the possibility of parole for the rest of their lives. We refused to let anger guide our judgment. We stood firm, even when vengeance called louder than mercy, to the unwavering belief that human dignity is never extinguished. This judgment reminded us of the deeper purpose of constitutional justice: to protect principle, not popularity; to act with resolve, not retribution; to protect the worst and weakest among us, as Justice Jacobson wrote, so that we can all be secure, that our rights are protected. And just as our court borrows from your insights, we are honored that our judgments sometimes influence yours. What has emerged is a relationship of trust, a form of judicial kinship that transcends geography. As far as long-distance relationships go, our works pretty well. We have not only read each other's judgments, we have reflected deeply on each other's values. Together, we lead in the area of living constitutionalism the idea that the Constitution is not a relic for a museum, but a dynamic force capable of adapting and evolving as society progresses. On this 30th anniversary, we reflect upon what has been achieved with admiration, but also with hope for what lies ahead. The path of constitutional justice is never static. New technologies, shifting politics, global crisis, and evolving norms all place new demands on our courts. But in this era of complexity and change, the importance of international judicial dialogue has only grown. The experience of South Africa and the jurisprudence of this court continue to serve as a guiding light. You have shown the world that constitutional law can be a tool of transformation, not just preservation. You have demonstrated that courts can be agents of hope, grounded in the reality of people's lives. And you have reminded us that legal reasoning, when paired with courage and compassion, can build bridges over even the deepest of historical divides. In closing, let me once again offer my heartfelt congratulations to the South African Constitutional Court on this extraordinary milestone. Your achievements in the past 30 years have been nothing short of remarkable, and your influence will only continue to grow. Thank you again for inviting me to join you today, and may we continue to work together for justice, for equality, and for human dignity. Thank you very much.
Thank you, Chief Justice, for your lucid presentation and for the continued support to our court. I'll remind you that we look forward to further engagement with you and your colleagues at your court. The next speaker, we have session 3. It's going to be messages of support from the other courts. This presentation, each speaker has been given 5 minutes to just say a few words in support, not the 15 minutes that we have been using. They are aware of that. I'm not changing anything. The first speaker is the Honorable Chief Justice of Botswana, Honorable Chief Justice Hitlo Kgetso. Thank you.
Yes, thank you so very much, Madam Program Director. I will stand on the already established protocols, but I think it would be remiss of me not to recognize the presence of the former President of South Africa, His Excellency Thabo Mbeki, and I recognize his presence. Now, ladies and gentlemen, you see, when we come from Botswana, and you come to South Africa, and you want to pretend that you are a Chief Justice, you may fall into problems. There was a time I came here as part of a training process run by Sajay. And I was assigned an officer from the VIP protection. And we had a discussion in the vehicle. He asked me how many people are there, and I told him we're 2.3 million. Then he asked me whether we have a president. When I told him, yes, we have a president, of course, then he asked me whether we had a cabinet. I said, yes, we do. He said, for 2.3 million people, what are they doing? So, I don't know. But I told him, yeah, we do. So I stand here humbled by the invitation that has been extended to us by my sister, Chief Justice Maya. And my message will be very, very short. The invitation came in, I accepted. It was followed by a reprimand that we will give you a slot, but you should only speak for 5 minutes. So I'm not going to breach that. And I recognize all of you here, colleagues. The other issue that I want to mention is that you see Botswana, meaning the people of Botswana, and South Africans are very, very close. During the times of apartheid, some of them came to Botswana as refugees, or they were just passing through as part of the cadres of the liberation movement. Some of them stayed in Botswana as professionals. They were teachers, and some of them were lawyers. I stand here very, very proud today because when I started law practice in Botswana, I worked in an office that was established by a former South African and none other than President Thabo Mbeki's brother, Jammeh Mbeki. So that's why I started my law practice. And I'm here today because I learned from the great. I didn't see him myself. I saw his name in the office. I saw the book that, yes, I saw his handwriting. And that office is still there. It has produced 2 justices. One of them ended at the Court of Appeal, and the other is here today pretending to be a Chief Justice. Now, the dawn of democracy in South Africa in 1994 heralded a new era for constitutionalism, not only in South Africa alone, but also in Southern Africa in general. The Republic of Botswana shares a legal heritage with the Republic of South Africa, Lesotho, Eswatini, Namibia, and the Republic of Zimbabwe, all of whom, you see, this technology sometimes has a problem. Yes, I think I'm sorted. All of which have the Roman Dutch law as their bequeathed common law heritage. From the certification of the draft constitution to Makwanyane and the treatment action campaign cases through to the Zuma corruption case, the birth of the Constitutional Court of South Africa shortly after the liberation of the Republic of South Africa has had a profound effect on constitutionalism and human rights jurisprudence in all our jurisdictions. It has proven to be a torchbearer in constitutional jurisprudence. As Botswana, for instance, we have taken a further step, or the further step of having former judges from this court who sit in our Court of Appeal. We have 2 justices, my friend Edwin Cameron, and our sister Best Nkambinde, who sit in our Court of Appeal. We have another justice from South Africa who sits in our Court of Appeal. We have also had relations with the South African courts, particularly through Sajay. Most of our judges who come in, and I was talking to Justice Majid this morning, and Justice Matopo, trying to go and train more judges, and Justice Where's my sister? Your job is waiting, Botswana, to come and take care. Therefore, the celebration of the establishment of the Constitutional Court of South Africa is as much our celebration as it is a celebration for the people of South Africa, the African continent and beyond. Like the founding president of this republic, that is the Republic of South Africa, Nelson Mandela once said in his autobiography, Long Walk to Freedom, "We have climbed the hill, but the journey is not yet complete. There are mountains of constitutionalism still to be climbed, and as our collective democracies, we face more human rights and constitutional challenges. I trust and I believe that this court, that is the Constitutional Court, when called upon, it will, as it has always demonstrated, climb the mountain with renewed vigor. As a country, we share South Africa's strong democratic ethos. We know and we believe that meaningful development is not possible in an environment where the constitutional rights of the ordinary people are not respected and protected. South Africa in this regard, and through the Constitutional Court, has been, and it seems it will continue to be the case, commanded a leading and exemplary role. Botswana will soon be engaging in a constitutional review process, and one of the things being seriously thought about is the establishment of a constitutional court. Don't ask me whether a country with 2.3 million will need a constitutional court. Obviously, there will be a lot to learn from the South African experience. My friend, my sister, late Chief Justice Maya, I bring a congratulatory message from the government of Botswana, the people of Botswana, as well as from our judiciary. And we wish you and the Constitutional Court and the people of South Africa and the Justice of South Africa the very best going forward. Thank you so very much for your attention, and may justice and human rights prevail forever. Thank you.
Thank you, Chief Justice. I was just about to stand up. Thank you very much. Thank you for the message. The President of the Supreme Constitutional Court of Egypt, the Honorable Femi Boulos, is the next speaker who will also give us a message of support. Thank you.
Good morning, everybody. سيادة القضية مهندسة مايا رئيسة قضاة المحكمة الدستورية بجمهورية جنوب إفريقيا، أصحاب السعادة والمعالي أعضاء المحكمة الدستورية بجمهورية جنوب إفريقيا، السادة أصحاب السعادة والمعالي القضاة.
Channel 1 for English, 2 for Arabic, 3 for Portuguese.
السيدات والسادة الحضور الكرام، في هذا المقامر المهيب وفي رحاب القضاء الدستوري الإفريقي أتشرف بأن أنقل إلى سيادتكم وإلى المحكمة الدستورية بجنوب إفريقيا أسمى آيات التهنئة والتقدير من المحكمة الدستورية العليا بجمهورية مصر العربية قيادة وقضاة بمناسبة مرور 30 عاما على تأسيس صرحكم القضائي الشامل. السيدات والسادة، إن ما نحتفي به اليوم ليس مجرد ذكرى تأسيس مؤسسة قضائية دستورية، بل هو استدعاء لمسيرة نضال وطني إنساني اختارت فيها جنوب إفريقيا دولة وشعبا أن تجعل من القضاء الدستوري ركيزة لبناء ديمقراطية حديثة ومحركا لإرساء العدالة الانتقالية ومرجعية راسخة لمبادئ الحرية والمساواة وكرامة الإنسان. لقد نشأت محكمتكم في قلب لحظة فارقة من الزمن، ليس فقط في التاريخ الوطني لبلدكم بل في ضمير القارة الإفريقية بأسرها، لتكون تجسيدا حيا لقدرة القانون على ترميم الذاكرة وتصحيح المسار وبناء الثقة بين المواطن ومؤسسات الدولة. ومنذ نشأة محكمتكم لم تكن حارسا للنصوص فحسب، بل ضميرا يقظا لحماية التوازن بين السلطة والمواطن، وصوتا ناطقا بعدالة تخاطب الحاضر وتؤسس للمستقبل. السيدات والسادة، إن تعزيز دور المحاكم الدستورية في إفريقيا ليس مسألة قضائية فحسب، بل هو رهان حضاري على قدرة دولنا في الدفاع عن منظومة الحقوق وتثبيت دعائم الدولة القانونية وإعلاء صوت المواطن. إن مصر التي آمنت مبكرا بدور القضاء الدستوري وأسست محكمتها الدستورية منذ نحو 60 عاما مضت، ترى في هذا المسار الإفريقي المشترك فرصة لتلاقي الخبرات وبناء جبهة قضائية موحدة قادرة على الإسهام في تكريس حكم القانون في عمق المشروع القادم. وبهذه المناسبة أستميح سعادة القاضية مايا مانديسا أن أطلع الجميع على توقيع بروتوكول تعاون قضائي هو الأول من نوعه في دولنا وبين محكمتينا. تم يوم الأربعاء الماضي توقيع اتفاقية بروتوكول يمثل مصر فيها المركز الإفريقي للدراسات الدستورية القائم على مسألة استضافة علماء وباحثين في القانون الدستوري من كل أنحاء العالم، فضلا عن القضاة هذه المحكمة، لنتدارس معا ونتبادل الرؤى والخبرات ونقابل التحديات التي تواجهها المحاكم الدستورية، ونستضيف من يرغب من قضاة المحاكم النظيرة في لقاءات مثمرة نعضد بها جبهة العمل الدستوري. هذه البشرى أزفها إليكم في هذه المناسبة، وأثمن غاليا الجهد الكبير الذي قامت به سيادة القاضية مانديسا مايا وكل فريق العمل معها في إقرار هذا المشروع. السيدات والسادة، إننا نؤكد من هذا المنبر دعمنا لتعميق التعاون بين المحاكم الدستورية في قارتنا. نرى في هذا المسار ركيزة من ركائز المشروع الإفريقي المشترك نحو الاستقرار والتنمية وتكريس الحكم الرشيد، وذلك من خلال تعزيز الآليات القضائية وتبادل الخبرات وتطوير الحوار الدستوري العابر للحدود بما يخدم قضايا القارة وتطلعات شعوبها. ختاما أيها السيدات والسادة، أجدد باسم المحكمة الدستورية العليا بجمهورية مصر العربية التهنئة الصادقة والتقدير العميق لمحكمة جنوب إفريقيا الدستورية قيادة وقضاة، متمنين لكم دوام التوفيق في حمل الأمانة العظيمة وإعلاء شأن العدالة الدستورية خدمة للإنسان وصونا للمؤسسات وتكريسا للقيم نتقاسمها جميعا. والسلام عليكم ورحمة الله وبركاته.
Thank you very much, Chief Chief Justice, the Chief Justice of the Kingdom of Eswatini, Honorable B. Mpalala. Will you kindly come over, please? Thank you.
President Mbeki, my lady, the Chief Justice, all protocol observed. Before I make my brief speech, let me congratulate the Judiciary of South Africa for the statement that was made this morning by the President of South Africa with regard to judicial independence. Congratulations. I will address you in my capacity as the chairperson of the Southern and Eastern Africa Chief Justices Forum. We meet here today to celebrate a great milestone of achievement by the Constitutional Court of South Africa. This achievement has been evident and reflected in the quality of judgments made in pursuit of the promotion and protection of fundamental human rights and freedoms of the people of this country. As we celebrate this day, we should acknowledge the reality that the Charter of the United Nations is ineffective. The Charter constitutes foundational treaty of the United Nations. The Charter mandates the United Nations and its member states to maintain international peace and security, uphold international law, and promote universal respect and observance of fundamental human rights and freedoms for all without distinction. However, the genocide committed in Gaza and the West Bank is testimony to all that the United Nations is not living up to its obligations. The Charter embraces the principle of sovereign equality of all its members as well as self-determination. However, the principle is not observed by the United Nations pursuant to the provisions of the Charter. The Charter embraces the Security Council as one of its principal organs, with 5 permanent members having veto powers. And this provision negates the principle of sovereign equality of member states. Accordingly, the Security Council is not capable of executing its mandate of maintaining international peace and security objectively without embracing the individual narrow interest of the permanent members of the Security Council using its veto power. Furthermore, the Universal Declaration of Human Rights, together with the International Covenant on Civil and Political Rights, have not benefited the African continent, the people of Gaza and the West Bank, as well as the developing world, notwithstanding the existence of the International Court of Justice, which is another principal organ of the United Nations. In terms of Article 59 of the Statute of the International Court of Justice, the Court's decisions are binding on parties with respect to the particular case. However, you are all witnesses that the decisions of the ICJ are ineffectual because the court lacks the enforcement mechanism to execute its decisions. I think the judiciary is aware what happened last year at The Hague when South Africa presented its case. As I conclude my speech, I would like to state that member states of the African continent have succeeded in obtaining their political independence from colonialism and imperialism. However, the economic independence of the African people remains a hollow dream due to neo-colonialism. The colonial masters have returned to Africa to loot the natural resources of the African people, leaving the African people in abject poverty. What is happening in the Democratic Republic of the Congo, Libya, and many other African countries explains the puzzle
why the African people remain poor when the continent is endowed with so many natural resources. May I, before I sit down, congratulate you, my lady, the judiciary, for this important occasion, and also for inviting us to be part of this ceremony. I thank you, and may God bless you.
Thank you, CJ. You even have a minute left. I'll call upon the President of the Constitutional Council of Mozambique, Excellency President El Ribeiro, to the stage. Thank you.
Good afternoon. Thank you. Her Excellency Mandisa Maya, President of the Constitutional Court of South Africa, Excellency President Thabo Mbeki, all protocol observed. My first words in the name of the Constitutional Council of Mozambique are meant to both thank and congratulate you on the occasion of today's 30th anniversary of the Constitutional Court of the Republic of South Africa. And a very sincere thank you for the great honor for being invited to address you for such a fortunate reason in this podium. Also, on this occasion, my earnest greeting to you all. To Her Excellency Mandisa Maya, President of the Constitutional Court of South Africa, and to the Justice, I extend my greetings of continued success in your noble role in favor of constitutional justice, peace, stability, and democracy in your country and in the region in particular. And I encourage you to continue the brilliant trajectory of this august institution, which over these 3 decades has been a living testimony to the resilience of the constitutional justice, even in the face of the most complex political, social, and historical challenge. Excellencies, ladies and gentlemen, celebrating 30 years of the existence of the Constitutional Court is an institutional achievement that means the celebration of current and sometimes challenging journeys are milestones that call for deep introspection and reflection. South Africa's Constitutional Court was created at the dawn of democracy, a crucial moment in the country's history, as one of the fundamental pillars of the new social pact established with the Constitution, internationally recognized as one of the most progressive in the world because it affirmed fundamental rights and idea of the centrality of human dignity, equality, and freedom, not as an abstract ideal, but as a concrete response to the deep wonders for the past. And since then, the Constitutional Court has taken up the role of guardian of this new social contract, ruling in emblematic cases that have shaped the course of South Africa's society, promoting justice, reconciliation, and respect for the fundamental rights. So much so that its 3 decades of jurisprudence is an obligatory reference in academic and judicial circles in the continent and beyond. South Africa's Constitutional Court has been a touchlight for emerging democracies, providing that it is possible to build a strong institution in a context of great social, cultural, and political diversity. Excellencies, honorable guests, allow me to make a few remarks about the proximity between Mozambique and South Africans. We are a broad nation, united by this history of struggle against oppression and by the commitment to the self-determination, freedom and justice. Geographical borders are more tenuous than these historical ties I mentioned. We share the dreams of liberation from segregationism and colonialism. We have consented to mutual sacrifice in favor of these goals. Solidarity between our people has been marked by political, military, and humanitarian support. In this solidarity, we remember, among others, and greet with particular respect and admiration the Honorable Justice Albie Sachs, who was the victim of an attempt on his life in Mozambique territory. The victory we celebrate today, such as the construction of democracy, states, and the creation of the institution that guarantee the fundamental rights of our citizens, are the fruits of this historic solidarity. In this context, the celebration of the 10th anniversary of the Constitutional Court of South Africa should be an opportunity to reaffirm these deep ties through judicial cooperation and the exchange of jurisprudential experience. Compared to the sum of its African counterparts, Mozambique Constitutional Council is still a young jurisdiction. Our first constitution, which coincides in time with the national independence on 25 June 1975, is now complete 5 decades old. But the separation of power and the institutionalization of the Constitutional Council was promoted by the second constitution of 1990. However, the Constitutional Council came into being 30 years later on 30th of November 2003. In these short journeys, we have found inspiration in the commitment of the region courts in general and South Africa's Constitutional Court in particular to defense of fundamental rights and guarantees. Having already made an invaluable contribution to the definition and affirmation of our rule of law, the challenge we have faced requires institutional courage, interpretative wisdom, and constant dialogue with the society. So, as a final note, I would like to express my hope that this celebration will lead to a deepening of cooperation between our courts through forums for dialogue, exchange of case law, joint training and sharing of good practice, renewing our commitment to judicial integrity, impartiality and independence, values without which there can be no true constitutional justice. And may our courts remain institutions where the most vulnerable find protection, active institution in preserving the rule of law, institution of civic courage and fidelity to the Constitution, which are the voice of legality, justice and hope. Muito obrigada pela atenção dispensada.
Thank you very much, Chief Justice, President of the Court. Honorable Chief Justice Chivute, the Chief Justice of Namibia, I call upon you now to make your message of support. Thank you.
Your Excellency, former President Mbeki, the Honourable Justice Maya, the Chief Justice of the Republic of South Africa, the Honourable Acting Deputy Chief Justice of South Africa, Your Excellencies, Presidents and Chief Justices of Constitutional Council, Constitutional Courts, and Supreme Courts. Distinguished ladies and gentlemen, I stand before you to join you which I consider to be a distinct honor in commemorating the 30th anniversary of the Constitutional Court of South Africa, a court that has since its inception played a key role in advancing constitutionalism, justice, and the rule of law in South Africa and across the region. The establishment of this court marked more than the creation of a new institution. It signaled a profound shift, a turning point in the country's legal and moral landscape. At a time when public confidence in the justice system needed rebuilding, this constitutional code emerged as a stabilizing force, principled, deliberate, and committed to ensuring that the rule of law would anchor the new democracy. Its role in helping to shape and secure South Africa's constitutional transition is widely recognized and remains a point of reference for many, including for those of us in Namibia, where our courts faced similar demands during the early years of constitutional implementation. Namibia and South Africa share more than just a geographical border. Our histories are intertwined, our peoples linked by a shared struggle for dignity, equality, and justice. With closely related legal systems, we have often looked to each other in our respective journeys of transition and legal development. In many respects, our legal systems have evolved alongside one another. In that spirit, Namibian courts have consistently drawn on the jurisprudence of this court, often finding in its judgments both legal clarity and principled reasoning that resonates with our own constitutional framework. In fact, such had been the proximity to closeness of our two jurisdictions, that at one point in our histories, to be exact, from 1997 to 1999, our countries shared Chief Justice Ismail Mohammed as the Chief Justice of South Africa and Namibia, and I may add for emphasis, at the same time. Indeed, the Constitutional Court of South Africa has long served as a persuasive voice in the Namibian legal context. Its decisions have been cited across a wide range of matters. What distinguishes this court's body of work is not only the intellectual rigor it reflects, but also the way it grapples earnestly with the lived realities of those affected by the law. Another hallmark of the court's legacy is the manner in which it has preserved its independence, or preserved rather its independence, while remaining accessible and accountable to the people it serves. Maintaining that delicate balance is no small feat, particularly in an era when courts around the world are increasingly drawn into matters that touch on sensitive political and social questions. Yet, it's precisely this balance that sustains public confidence and affirms the judiciary's role as a neutral guardian of the constitutional order. It would be remiss of me not to take this opportunity to once again congratulate Justice Madesia Maya on her well-deserved appointment as Chief Justice of South Africa. Her elevation is significant, not only as the first woman to hold this esteemed office, but also as someone whose judicial journey reflects dedication, distinction, and a deep commitment to the rule of law. We look forward, Madam Chief Justice, to the continued evolution of the Constitutional Court under your stewardship. To the court itself, congratulations on this remarkable milestone, 30 years of jurisprudential leadership, courage in the face of social complexity, and an unwavering commitment to the Constitution is no small feat. Congratulations on the 30 years of dedicated service to the Constitution and to the people of South Africa. May the years to come be marked by the same independence, insight, and integrity that have defined the court's first 30 years. May it continue to serve as a forum where justice is not only done, but seen to be done, and where the Constitution is not simply preserved or preserved, but animated in the service of the people. And thank you.
Thank you very much, Chief Justice. I know we have now almost taken time, which we should have been reserved for lunch, but I think there are only 2 speakers remaining, and I propose that we finalize that before we break for lunch. I call upon the Chief Justice of Nigeria, the Honorable Kekere Ekun, to make a few messages of support. Thank you.
The former President of the Republic of South Africa, Mr. Thabo Mbeki, Chief Justice Mandisa Maya, distinguished guests, ladies and gentlemen, it is with profound honor and deep respect that I stand before you today representing the judiciary of the Federal Republic of Nigeria to extend warm congratulations on this landmark occasion, the 30th anniversary of the Constitutional Court of the Republic of South Africa. 3 decades ago, this court emerged as a beacon of justice and constitutional renewal in a country that had chosen with courage and conviction the path of democracy, equality, and the rule of law. Since that transformative moment, the Constitutional Court has stood not only as the guardian of South Africa's constitution, but as a source of inspiration across the continent and beyond. In this court's jurisprudence, we have witnessed the power of law to heal a nation, to confront injustice, and to advance human dignity. Through fearless adjudication, judicial independence, and unwavering fidelity to constitutional values, you have demonstrated the capacity of courts to be agents of social transformation. Your landmark judgments continue to echo far beyond South Africa's borders, affirming that the Constitution is not merely a legal document, but the living embodiment of the people's collective will and aspirations. As fellow custodians of the rule of law, the Nigerian judiciary has drawn deep inspiration from your pioneering decisions and principled stance in defense of democratic ideals. Your work reminds us all that the constitutional courts play a vital role, not just in resolving disputes, but in shaping just societies. I'm especially honored to deliver this message, having recently had the privilege of visiting Cape Town in April this year to attend the 17th Biennial Conference of the International Association of Women Judges, IAWJ, where my fellow delegates and I were graciously received by His Excellency President Cyril Ramaphosa and the Honorable Chief Justice Maya. That visit deepened my appreciation of your country's remarkable legal heritage and enduring strength of your institutions. Today's celebration stands as a powerful affirmation that the Constitutional Court remains a beacon of constitutionalism and judicial excellence on the African continent. On this joyous anniversary, I salute the founding justices whose vision laid the foundation for this great institution, the current justices for their continued service with distinction, and all who have contributed to the court's legacy of justice, courage, and excellence. May the Constitutional Court of South Africa continue to flourish, to inspire the ideals upon which it was founded for this generation and those yet to come. Thank you most sincerely and congratulations.
I salute you, Chief Justice, for promptness and keeping time to time. Thank you. Chief Honorable Mr. Justice P. Mittal from the Supreme Court of India. I think he's going to be speaking on behalf of the Chief Justice of India. Thank you.
Namaste. A very good afternoon to all present in this auditorium. Honorable Chief Justice, Madam Maya, my esteemed justices of the Constitutional Court of South Africa, dignitaries of the dais, distinguished guests, ladies and gentlemen. It is with immense respect and heartfelt gratitude that I stand before you today, here in the Republic of South Africa, to commemorate 3 decades of the Constitutional Court of South Africa, a beacon of constitutional justice in the modern world. I bring with me warm greetings and deep administration from the Supreme Court of India and from the people of my country who share with South Africa a special bond, grounded in history, independence, struggle, and our common constitutional aspirations. 30 years ago, South Africa took a courageous step, emerging from the long shadows of apartheid to embrace a future rooted in dignity, equality, and constitutionalism. That moment marked not just a formation of a court, it marked the birth of a moral institution committed to rebuilding a fractured nation through the rule of law. The Constitutional Court of South Africa has emerged as a beacon of democratic values, a fearless guardian of constitutional morality, and a global symbol of how law can heal the wounds of an oppressive past. When Mr. Nelson Mandela came to inaugurate this august building of immense national importance on 14 February 1995, in his speech, he said, and I quote, "Today, I rise not as an accused, but on behalf of the people of South Africa, to inaugurate a court South Africa has never had, a court on which hinges the future of our democracy," unquote. India and South Africa share more than diplomatic ties. We are united by a shared constitutional spirit. Both our nations, born from movements against injustice, have placed human dignity and social justice at the heart of our constitutional frameworks. Our courts, though shaped by different contexts, have been animated by a common vision that the Constitution must be a transformative force, not a static charter. India and South Africa are sister democracies born in pain but determined to forge paths bounded in liberty, dignity, equality, and fraternity. When India gave unto itself a constitution in 1950, it was deeply conscious of global trends. Our constitution makers took note of the South African framework of 1910, particularly in designing a stable yet flexible amendment process and a federal structure that balances unity with regional diversity. Our Article 368, with its requirement of a 2/3 majority mirroring South Africa's approach, ensures that constitutional changes remains principled and deliberative. Similarly, our Rajya Sabha, the Council of States, reflects South Africa's model of indirect election through proportional representation, giving voice to the regional aspirations and strengthening the union. We borrowed from you, and over a time, I dare say that you also drawn from our journey, creating beautiful symmetry in constitutional growth rooted in a common goal of inclusive justice. The establishment of a constitutional court in 1994 was not merely a procedural innovation, it was a moral reclamation. Under the inspiring leadership of figures such as Justice Arthur Chassaman and Justice L.B. Sachs, who brought to the bench their live resistance in injustice, South Africa reimagined what judiciary can be. not merely as an interpreter of laws, but a protector of constitutional soul. The efforts to diversify the bench, elevate black and female jurists, and transform legal culture have borne visible fruits. The court today stands not only as an adjudicatory body, but as a symbol of democratic renewal. As an Indian judge, I recognize in this transition echoes of our own journey post-independence, though the velocity and depth of South Africa's change is extraordinary and worthy of global emulation. The Constitutional Court, built with bricks from the dismantled prison, is now a monument of freedom that protects the liberty of every individual. The windows behind the judges gives a glimpse of every feet of those outside walking by. It is a daily visual cue that the power of judiciary comes from the people, and which reminds that the role of judges is to act in the interest of the people of the nation. The Constitutional Court's judgments have echoed far beyond South Africa's border. In Maikana, the court abolished the death penalty, aligning with the global human rights trends and drawing from the Indian Supreme Court's own jurisprudence in Bachan Singh's case, which restricted capital punishment to the rarest of the rare. The emphasis on human dignity and disproportionate impact on the marginalized is a lesson for all jurisdictions struggling with moral weight of state-sanctioned death. In Government of Republic of South Africa versus Grootboom, the court breathed life into socio-economic rights. The right to adequate housing was no longer aspirational. It became a justiciable right. In India, Olga Tellis foreshadowed this idea by linking livelihood with life, but our enforceable framework has become an example for global South nations navigating the tensions between resource limits and constitutional commitments. Most importantly, in economic freedom fighters' case, the Constitutional Court ruled in the illegal and costly security upgrades. In this case, the Constitutional Court insisted on executive accountability of ECOS, the Indian Supreme Court's own robust intervention in upholding institutional integrity, such as in the second judge's case. Your judiciary's courage in ensuring that no one, not even the president, is above law is both humbling and inspiring. Nelson Mandela and Mahatma Gandhi, two titans of moral resistance, stand as bridges between our histories. Gandhiji's early experience in South Africa shaped the philosophy of Satyagraha, which go on to inspire freedom movements across the globe, including Mandela's own journey. Mandela often referred to Gandhiji as a sacred warrior, and their legacies remind us that non-violence, truth and compassion are most powerful tools of justice. As an Indian in South Africa, I cannot help but to feel a sense of homecoming. Mahatma Gandhi spent 21 formative years in this country. It was in Pittsburgh that he was thrown out of frame, and it was on your soil that he founded his mission. The seeds of Satyagraha, non-violent resistance, were sown in South Africa. In the spirit of Ubuntu, I am because we are. I am because we are. Let us commit to deeper judicial dialogue, mutual learning, and solidarity. For justice is not a solitary pursuit. It is a collective enterprise that binds humans together. I conclude with the words of Mahatma Gandhi. I quote, "In a gentle way, you can shake the world. In a gentle way, you can shake the world." The Constitutional Court of South Africa has indeed shaken the world, gently, wisely, and enduringly. Today, as we mark the 3 decades of Constitutional Court of South Africa, we honor its bravery, wisdom, commitment, and to transformative justice. It has walked with the people, listened to their pain, upheld their dignity, and advanced their freedom. And the journey ahead is equally promising. As my floor timing is coming to end, I am reminded of India's leading judicial minds, and the architect of the Indian Constitution, Dr. B.R. Ambedkar, who in one of his Constituent Assembly speeches said, "The Constitution is not merely a document, it is a living soul that breathes justice, liberty, and equality." On behalf of the Supreme Court of India, I offer my deepest congratulations to the judges of this remarkable court. May your flame of justice continue to burn bright for South Africa, for Africa, and for the world. Thank you. Vaidanki, Jayati, Jayati, Mam Bharatam.
Thank you. He is the messenger, so and thank you very much. The Chief Justice of the Supreme Court of Kenya, Mr. Justice Lenwala. Thank you.
Thank you, Director of Ceremonies, President Mbeki, Chief Justice, colleagues, good afternoon. Good afternoon, please. I know that I'm between you and lunch, so I'll be exceedingly brief, lest I'll be accused of flouting the right to food. Chief Justice, I bring greetings from the Chief Justice of Kenya. My elder brother, Justice Moseneke, this morning congratulated me on my appointment as Chief Justice. So have you, from your lips to God's ears. I am of the Supreme Court of Kenya. I represent my Chief Justice, Martha Koome, who could not come. So receive her greetings and congratulations. Number two, I want to thank this court for the work you've done over the last 30 years. We in Kenya are beneficiaries of your jurisprudence, and particularly myself. I was the head of the Constitutional Human Rights Division of the High Court until I rose to the Supreme Court. And between 2010 and 2016, I can't remember the number of times, I quoted Makanywane, One Olivia Road, Byward Trust judgments, and many others. And so we thank you for laying the foundation for our court, which is only 12 years old. We were set up in 2010 after our new constitution, and as some of you may know, the Bill of Rights in our constitution is heavily borrowed from your Bill of Rights, and therefore our interpretation and application of the Bill of Rights borrows heavily both from your constitution and of course your jurisprudence. Having so said, I also want to thank some of the judges of your court who were instrumental in bringing Kenya to peace and to stability. Judge Johan Kriegler, we thank you. When you came after the tribal clashes of 2007, 2008, you laid the foundation for what we have today as our electoral system. And as we go to elections in 2027, your spirit, your words linger, and they remind us of the need to retain peace if we are to have a true democracy as we must all aspire to. I want to thank you. I want to thank you, Justice Albie Sachs. You came to Kenya again after 2010 as part of a panel that was vetting all judges sitting in Kenya at the time, including myself, to determine our suitability to serve under the new constitution. It was part of that process that triggered what we are calling today in Kenya true transformation of our judiciary, from a judiciary of corruption, a judiciary of incompetence, to a judiciary today celebrated like yours across Africa. We thank you, Albie Sachs. Number three, Chief Justice, a few years ago, we had a joint program between your court and our court, where your law clerks would come to Kenya, and our law clerks would come here. That program collapsed. I now plead with you from this podium, President Mbeki, please tell her to listen to me. Let us revive that program. I'm a beneficiary of that program because my law clerk came here, clerked for Justice Moseneke, introduced me to Justice Moseneke, was remained a good friend since my law clerk came here. If we could please revive that program to be useful to both our courts and to develop our young lawyers. And while I'm on that, Chief Justice, we may need to have an MOU in terms of training, in terms of exchange of ideas, and just between our two courts. And since I lead in the program of engaging with international courts, I hope that before I go, you can give me one of your judges, we can have a drink in the evening, and draft one MOU which we'll share with you and our Chief Justice. And I can go with a draft to my Chief Justice, and we get this going. Lastly, I promise to be brief. Lastly, I wish this great court, under your leadership, Chief Justice Maya, more years of great leadership in creating indigenous African jurisprudence, and with the spirit of Ubuntu, bind all our courts to greater success. And so I thank you for listening to me, and I hope when I go back to Kenya, I can carry your greetings to the Supreme Court of Kenya, to my Chief Justice, and the great people of the Republic of Kenya. I thank you.
Thank you very much, Justice. And on the law clerks issue, we are definitely working on that. It's trying to get funding. I'm talking my head as the chairperson of the Constitutional Court Trust. We're definitely working on that. Now, thank you to the audience for your patience. We should have adjourned for lunch a long time ago. We are now going to adjourn for lunch. It will be a 30-minute break. On my clock, if I were in court, I would say at 1:45, but because it's just over 2:15, I'll give you the extra 4 minutes and say 2:50. We'll come back for lunch. There are two marquees across us where lunch will be served, and there's a hall behind the marquee. Also, the lunch will be served there. There are officials who are there waiting for the former judges of the Constitutional Court, the former president, the justices of the Constitutional Court, heads of court, and the guests that are on the stage. They'll be taken through to the hall, and the rest of the other guests will then be in the hall. And if there's an overflow, the two marquees are available. If you want to sit in the lounge, you can go in the atrium, take your food, and enjoy your food in the atrium. But at 10:02, we will proceed with our program. Thank you very much.
have to accommodate to a colonial type building and a set of procedures that are laid down and in some ways reminiscent of the past, reminders of a horrible past, not beautiful reminders of a distant past, horrible reminders of a recent past. And we had nothing. Actually, I lie. We had one chair. And I know we had one chair because when Arthur Chaskalson stepped down from the court as Chief Justice, like 10 years later, Dorothy Fouché, his secretary, said how terrifying it was being interviewed for the job as secretary, sitting in the one chair the court had, with this tall figure circling round, firing questions at her. Actually, maybe it wasn't nothing and one chair. We had a constitution. Wasn't the final constitution, but it's a constitution that enabled our people to vote and choose the body that would draft the constitution, and an interim Bill of Rights. And in a sense, we were in the same country geographically, but another country in terms of possibilities, in terms of imagination. The first meeting, it was November, it was a hot day, and we were in temporary accommodation in Brown Park, not too far from here. The word motley, I'm looking at the members of this new court. We could hardly have been more motley. The only person who really looked like a judge was Arthur Chaskalson, and he'd never been a judge. The judges from the old regime who'd been judges, they didn't like being a judge, the formality, the ponderousness, the rule-driven, stereotypical way of behaving as a judge. They had people with passion, with heart, and they felt the agony of being judges, believing in law being useful and good and virtuous in a framework of functioning in a society where the constitution was evil. The country was based on oppressive laws and oppressive constitution that had given them a passion and a verve and a questioning of law, not simply taking for granted we're just going to get on with our jobs. I had come from London. I'd been in exile there for a long time. And there's a shop called Simpson's in the Strand, I think, that sells clothing for guys basically going to the tropics, British gents who don't want to sweat too much under the hot Mackay sun. And I saw a very beautiful sort of poplin light-coloured suit. I thought, great, I'm going to wear that. With some pain, I cut off the side to measure my arm. I'm wearing that. Ismail Mohammed comes up to me very stern. Albie, that's not a suit for a judge. I mentioned that to convey the motley character in personalities, in backgrounds. Brilliant, sharp. John Didcot, the booming voice. The security police were afraid of him when he was on the bench. And he would cross-examine the security police to bring out the torture. So there we were. So different from the image, the version imagined of a judge. I've never imagined I'd become a judge. I was there on the other side. I liked good judges, the few good judges we had. I tried them suddenly. And I remember Marty Stander, who was the sort of secretary, saying, "Judge," and I turned around. And I realized she's speaking to me. Arthur played a hugely important role in how do you make something out of nothing. The very first thing was delegating tasks and functions. We're a team. He had given up private practice, the most sought after barrister advocate of his age, to set up the Legal Resources Center. He'd set up an institution. He knew about all the practicalities of organizing or functioning. And that experience he gained was enormously valuable in establishing the court now as an institution, a functioning institution. And we had to take some very quick decisions. I'll come to the delegating in a minute. They were questions not of legal rules, of jurisprudence, of legal culture. Not enough is spoken about legal culture, the culture of lawyers. Our culture was a very masculinist culture for over 150 years or so, of smart, sharp-witted, often abrasive, sometimes beautifully collegial men in the legal profession, going onto the bench, sometimes being witty, sardonic, whatever it might be. But also a culture where people would love using Latin. It showed you were learned. And one of our first decisions was no more Latin. No more Latin. We weren't thinking along the lines of decolonization and Roman Dutch law. It wasn't an abstract philosophical view. We just saw Latin would be an impediment in the new South Africa. It would have a huge racial element because lots of white kids learned Latin at school and it meant it was exclusionary, no more Latin. Even inter alia, we didn't say inter alia amongst other things. We had to keep prima facie because we couldn't find anything else for that. No more my lord, my lady. We didn't like that. We felt it was actually cutting us off from the people. It wasn't, we had to get our prestige, if you like, through our work. We had to earn it, not inherit a title that as a caste kind of a thing. Strangely, we thought all the other courts would follow us. Now it's only, there are lots of lords and ladies in the other courts in South Africa, and only in the top court it's justice, sometimes CJ, whatever it might be. When it came to a simple thing like seating, we didn't have fixed seating. We didn't want the idea, the head of the court, the second oldest, the third oldest, the kind of seniority. And who was more meritworthy? Johan Kriegler, who'd been a judge for many, many years, with brilliant judgments and sparkling personality, erudite and in tune with the new values of the country, or Albie Sachs, who'd spent months in jail. Do you proportionally value your contribution to the struggle? Or Arthur Chaskelson, who'd never been a judge, but just been a magnificent. We didn't want hierarchies in our ranks, but we also were Democrats. We loved the idea of debate and discussion and sharing. So we decided not to have fixed seating in the court. The head of the court they called the president, the deputy head in the center because they preside, and every term we would rotate the seating, just to encourage that sense of equality amongst the judges, equality in discussion. We had great discussions. We never discussed our cases before hearing. We didn't want to be influenced by what our colleagues might feel. And you'd be very curious to know, to find out, the most somebody might say, it shouldn't be a long hearing, or I think it's going to be a long hearing. That was the nearest to sharing your own personal views. And we go round the table, round and round and round. It was an oval table, so in the ellipse, whatever it is. And people would speak once and twice and three times. It was like workshopping. And I believe that was maybe unique in the world. And more recently it's become more structured, with papers being presented. Then we loved the idea of speaking hot from the press, burning hot, to come out with interactions and debates. So that was one phase now of establishing a new kind of a personality. And I am sometimes asked about the qualities of the judge that you want. Of course you want judges who are clever and thoughtful and empathetic. But 3 C's came to mind. One is civility. Civility isn't just politeness. Civility is respecting the process, respecting the issues, respecting the counsel, respecting the clients, respecting your colleagues. And that's where Arthur was superb. Not all my colleagues were civil. And some of my most brilliant colleagues were wonderful, but they could be very sharp. Arthur was never sharp. He was always thoughtful. It set a tone, and we had amazing discussions amongst ourselves. And the second was collegiality. Collegiality is you are a team. And it would go so far when we would have read-throughs at the end, so that no judgment would go out without being checked and agreed to in terms of the text by everybody. We would help our colleagues who disagreed with us. I remember once saying to Zach Jacob, Zach, your dissent from the majority view would be stronger if you phrased it in this way or that way or the other. It was the quality of the product that mattered to us. We had moments of tension. There were times when we cried. 2 men and 2 women cried. I'm just going to mention that. It's not pain-free and it's not automatic, but it was heartfelt, and that sense of this is something not just for us, it's for the nation, it's for the people, and we have this amazing thing that we are entrusted with a possibility, a responsibility to carry forward what people have been dreaming of and fighting for and arguing for and so on. So that's now the first phase of what you can do with nothing. You do everything temporary in the sense of temporary, and by the way, the issues that Arthur delegated, Ishmael, will you do rules of court? We didn't have rules of court. You can't function without rules, boring rules. Ishmael loved boring rules. He was a real lawyer's lawyer. He wrote the most passionate, if we're going to have gowns, and we decided we would have gowns after quite a long discussion, will you go to Grahamstown, where they've been creating gowns since 1855 or something, and we got a gown that looked as though it had been created in 1855. But the important thing about it was different from the gowns from the rest of the court. And we had that paradoxical thing. We had to prove that we were real judges, but we had to prove we're not a branch of the court that functioned in the system of white supremacy. At that phase, there were 150 judges roughly in South Africa. 148 were white, and 2 were black. A slight imbalance. 149 were men. 1 woman. That's where we started from. We were now creating a new court that drew white men from the old judiciary who had resisted apartheid with whatever was available to them, who maybe had a particular feel for what law could do because of the way they'd been compelled and thrust into obnoxious use of law. Had a wonderful role with us, but we also had Yvonne Mokgoro with the Afro hairstyle, sworn in Setswana. It was revolutionary. Just that picture of this youngish woman using African language, saying that she will uphold. And we had Tolly Madala in IsiXhosa swearing the oath, and Pius Langa in isiZulu. And if I remember correctly, Johan, you used Afrikaans, and Laurie used half English, half Afrikaans. And I had a dilemma for myself, very secular person, but I wanted to raise my arm and struggle. And that meant saying, so help me God. And I raised my arm and I said, so help me God. And the believers believed that the province had something to do with it. I'm just mentioning, though, that kind of quality. And Kate O'Regan, can you tell us what these things called personal computers are? So Kate off down the line had to tell us about personal contribution. Everybody had some work except for Albie Sachs and Yvonne Mokoro. Oh, and Albie and Yvonne, can you look after decor? And here's 10,000 rand. Now, of course, 10,000 rands then was worth $2,000. And we actually bought one picture, a painting by Jocelyn Glover showing humanity. We had it made into a tapestry, and that was our first picture. I'm moving to the second phase now of making do. We needed a new logo. The old logo was quite a nice logo. It wasn't offensive in itself, based on European heraldry, with a lion and maybe a unicorn or a springbok. But it had been used for death sentences, Group Areas Act. It was associated with the stamp of the past. And we got a new logo. Is it up now? Yes. It's not the best representation physically. It's a little crisper and smarter than that. It's what it is, but it's more important, it's what it isn't. It isn't the blindfolded woman with the scales of justice. It isn't a copy of an imported vision of what justice is. We fought hard for our Constitution. We wrote it ourselves. It dealt with our pains and our hurts. And we felt our court must have its own logo. And Carolyn Parton came up with, we couldn't decide whether to have a tree, the Constitution, the Bill of Rights, the people, and a visitor to Arthur Chaskalson said, oh, why don't you put the people under the tree? And that fitted in with our notion. Now we want our own building. And we travel, we look here, we look there, we look everywhere. We come to not Constitution Hill, the old Fort Prison, overrun with weeds. Wits University used to have rave parties here. It was so, we said, yes, I remember Johan, you and I immediately just felt this is the site for its location but for its history. It's turning swords into plowshares. It's the continuity of struggle, of hope, but taking the negative energy and making it positive energy. And when I'm here this afternoon with yourselves, you know, even I'm giving myself goose flesh. I don't know if you can be such a good speaker, you give yourself goose flesh. But I'm giving myself goose flesh. We're sitting here next to the women's jail and thinking, you know, how right it was that we chose this site. And then we had an international competition for the building. And advice given by Jack Barnett, who'd been in the struggle, leftist architect who completed one project while he was in jail, and he said, Albie, have a competition. Public Works will give you a nice, ordinary, boring building. Have a competition. We had an international competition. And the brief was important. We said we don't want an ornate building representing state power. We wanted a warm, welcoming building that was inviting for people to feel comfortable in it. We don't want a building that represents the culture of any particular section of the community. We want a building that draws on the cultures of all our people in South Africa. And the jury was important. So we had Jeffrey Bauer from Sri Lanka, Charles Correa from India, and Peter Davey, British Architectural Review editor, and then local people, and I represented the court. Tenji Umtintsu is appointed. She said, why do you appoint me? I'm head of the Commission of Gender Equality, and you realize they're only men. She was absolutely right. Isaac Makhasi, who'd been locked up in number 4 jail, is the mayor of Johannesburg. He said if I told the gods that one day I'm going to be the mayor of Johannesburg awarding the prize for the architectural competition, they would have killed me. And Tenji, what am I doing here? You needed a woman. It's absolutely right. She became the most important figure on the jury. She said, I'm my mother, her mother. Her mother took washing from white families to send Tenji to school, university. And Tenji dropped out to join Umkhonto we Sizwe. It broke her mother's heart. She couldn't, and she said, I couldn't tell my mother that I joined the struggle. And only a year later, when she was on the run, had to go to Lesotho, she invited her mother to join her and said, Mom, I couldn't tell you why I dropped out of university. I was joining MK, and her mother said, Tenji, my daughter, I'm so proud of you, you're doing it for the nation. I'm telling you how the past comes into the future. And Tenji is now her mother, and her mother's frightened of modern buildings. And her mother says, her mother goes round to the back, or comes in with a piece of paper, can you take me to, I want a building that's smiling. To my mother. That's the one I like, number 62. And it had the theme of justice under a tree, traditional African way of settling disputes. And Peter Davies said it's the best jury he's ever been on, because normally the professionals fight amongst themselves, the lay people line up amongst the least exciting projects. Here the lay people went for the most exciting project, and you persuaded us. From that little symbol, to the building, to the site, to the artwork, it's not the Magna Carta, it's not Daumier cartoons, it's not pictures of dead white male judges. I always say that, one day I'm going to be a dead white male judge. If that's the only picture you see in an old building, it's saying only men mattered, only whites mattered. Sometimes the more banal offense is even worse than the very overt and vicious form of assault on dignity. So these are the things that we manage to create. And the last thing is something else that I'm going to end with, and with a certain forward projection. We weren't asked to give anything on the way forward, but I've got a feeling I'm not going to be around in 30 years' time, so I'm going to venture in that. The last case we had in that wonderful building dealt with people living not very far away in Johannesburg who were fighting for the right to have not concrete pit latrines, but ventilatorly improved pit latrines called VIPs. I don't know of another top court in the world that would see this as a constitutional matter. And the people walked to come to court. They were sitting in the court. And a certain Mbuyiseli Madlanga, who had actually acted on our court for a while before, and he said, you've got your pious Langa, I'm your mad Langa. He's now appearing for the province. And he starts off by saying, before I begin my presentation, I want to apologize on behalf of the court, to the court, on behalf of the province. We promised the people homes, and 3 years have passed and we haven't delivered the homes. And Dechang Mosaneki, who's presiding, says, don't apologize to us, apologize to the people. And Mbuyiseli turned around and spoke to Xhosa, and the people looked so pleased. And I felt also so pleased. And this is, it's an African way of doing things. After the Mr. Shilabana case, can a woman be chosen by the community to be the traditional leader? Other courts said, no, African custom doesn't allow. And we developed the notion of living customary law. The court is packed with people who come down in 2 buses, they slept in the bus, they fill the court during the day. At the end of the day, Pius Langa is presiding. He's asked one of his clerks who speaks Tonga, just thank the people for sitting so patiently during the day, hearing things in a language that's not their language, often very, very technical, for doing it with great patience. He didn't say, we're going to give you the judgment. It was just a connection. And if I'm looking forward to the next 30 years, maybe something can be done to help, shall I say, Africanize. It might be misunderstood. South Africanize. South Africanize. In Mozambique, you speak not about indigenizing. they spoke about Mozambicanizing. Mozambicanizing meant giving more to the culture, the feel, the ways of doing things of Mozambique. More to do things of that kind in the court. And maybe, CJ, you wrote the first decision in African language, set a wonderful example. Van Krechel wrote a decision in Afrikaans that was dealing with the language question. Maybe the language issue can be re-looked at, that people can be freer not to always work through interpreters, to use their languages in the way that people under the tree would use their language very, very freely. I don't know. And I also sense, I don't know enough about African culture. I know in Mozambique a colleague who was actually a missionary, his name was Joseph, and he fell in love with Mary, who was a nun, and they married. And he collected proverbs. And there's so much wisdom in African sayings. And it fits in with our Bill of Rights, a sense of fairness and justice and right. And I just have a feeling, in that sense, South Africanizing the South African Constitutional Court judiciary's way of doing things, without pointing fingers at backward people like me who don't speak African languages, without making us feel alien, just in ways, particularly at local levels, but not only at local levels. I feel that might be a future source of enrichment. My name has been mentioned quite often. I'm going to conclude with this. It's actually very embarrassing. Now, it's lovely, it's flattering, but that collegiality, we were a team, and I was flying on a magic carpet, and the magic carpet was the Constitutional Court of South Africa. The work we were doing as a team, and if that can be maintained, and I spoke with such pride and passion about the work that we'd been doing, so my name stood out a little bit. I am thrilled to bits with this conference, the energy of it, the feeling of it, the bonhomie. It's not Latin, I think that's a French word I'm allowed to use. And I thank you very, very much for having invited me.
Thank you, Alvin. The next jurist will tell us about how the jurisprudence of a new constitutional court was built. Please join me in welcoming Justice O'Regan to the podium.
Thank you very much, Justice Kipi. And I'd like to start by thanking Chief Justice Mandisa Maya for his honor to be standing here, and enormously delighted to be addressing you as the first woman Chief Justice. It seemed like a really important moment. And I'd like to greet all my colleagues, many of them former Constitutional Court judges, current Constitutional Court judges, judges from across South Africa, our honored guests from Canada, from Africa. It's really wonderful to have you all here. And also many colleagues and allies in the audience who, many of you are known, former law clerks, people who've run NGOs. It's really great to see you all in one room to reflect on 30 years of the Constitutional Court. Having looked at my watch, it seemed to me, and given the fact that I've asked to talk about the jurisprudence of the court, that brevity may indeed be the soul of wit in these circumstances. And I'm going to really reflect just on three questions, which is, why does building a constitutional jurisprudence matter? Who builds a constitutional jurisprudence? And how do we build a constitutional jurisprudence? But before I do so, I wanted just to acknowledge the first colleagues of the court who aren't here. And I was very pleased that Albie mentioned all of them. Chief Justices Chaskelson, Mohammed and Langa, and Justices Ackerman, Didcot, Nadala and Makoro. Members of their families are here. I've spoken to some of you. It is a sadness to me that they're not here today. So, why does building a constitutional jurisprudence matter? Well, a constitution at the end of the day is a series of words. Ours is not a short constitution. It's not as long as the Indian constitution, but it's not a short constitution. But it is, in fact, a basis upon which government has to act. There are people across the country who have to implement what is set down in a constitution. And when courts set down what a constitution means, it is important not only to lawyers, not only to the court, but to everybody who is tasked with fulfilling a constitution. Moreover, constitutional texts are often quite open-ended. So just reading the Constitution often doesn't give you a clear answer to the questions that arise as to how you should implement it. So when a court is preparing to give a judgment, to give guidance on what a constitution means, it is very important that it does so in a manner which is accessible to all those people who are going to be implementing the Constitution. So that's why building a constitutional jurisprudence matters. The second thing I wanted to address is who builds a constitutional jurisprudence. And the first thing I want to say is it's not only judges. Judges obviously are important. They write the words, they sign the judgment. But it really starts with litigants and lawyers who conceive of cases. South Africa has been enormously blessed to have an active civil society and an enormous range of litigants who brought cases to the court right from the start. I've spoken to judges from other jurisdictions who say, we just don't get the cases. That has never been the problem in South Africa. We have plenty of cases and an enormously rich array. If you just look across the first 3 years of the court heard cases across the Bill of Rights, a huge array of cases across the Bill of Rights. It heard cases in relation to the powers of the president. It heard cases about how Parliament should work. It heard challenges to bills. Because people were willing to take cases to court, to go through all the effort to put a case together and bring it either initially to the High Court or in rare cases to the Constitutional Court, they started building a constitutional jurisprudence. And that has gone on, and long may it go on. It's a really, absolutely major reason for the richness of the jurisprudence that this Constitutional Court has produced. But once it gets to court, there are a whole range of people, and one of the groups I want to reflect on a little bit today, and they're going to be talking to us later, Tembeka and Fani, is the role of the law clerks. The Constitutional Court was the first court that appointed law clerks, and it was one of Arthur Chaskelson's brilliant ideas. It always struck me that the law clerks, in many ways, were what kept the court honest. I felt every year when the law clerks came in with their deep commitment to the project, their excitement about the project, it was impossible for judges to become sort of routine, business as usual. It was law clerks who told us what people were going to think about our judgments when they went outside, and although sometimes we disagreed with them, we very often found that their guidance was invaluable. So there's a team within the court, particularly the law clerks, and many of them, of course, have gone on to important professional roles right across our society that build the jurisprudence of the court. And finally, and often less acknowledged, are the role that academics and scholars play in building a constitutional jurisprudence. No constitutional jurisprudence can flourish without people reading and working and criticizing and seeking to improve the work of the court. That is absolutely the case for South Africa. Just as we were blessed with litigants and lawyers who would bring cases, we were blessed with people who would write about the work of the courts. And long may that continue. I see some of you in the audience today, and I will say that I know jurisdictions where there's little work done on the role of the court. It's so easy to be wrong. It's so easy not to get things right, and academics and scholars really make an enormous contribution to the building of a constitutional jurisprudence. So that's both why and who. The last thing I want to speak to is how do we build a constitutional jurisprudence? Justice Chivute spoke earlier today, and I thought it was an enormous compliment to the court about clarity and careful principle and reasoning. I couldn't agree with him more. I won't say we always achieve that, but I think that should be our aim. And I think that I've expressed why that is important. Because if ordinary people cannot understand what the court says, if it's inaccessible or turgid or doesn't follow logically, it is very unlikely that that constitutional jurisprudence is going to be able to found sound government action and the behavior of people in our broader society. Striving for clarity, principle, and good reasoning seems to me absolutely the first thing we should do when we're trying to build a good constitutional jurisprudence. Perhaps more surprisingly, my next principle is incrementality. I will say that I think I was one of the quickest converts from judicial activism to judicial caution in the history of the world. I came to the court thinking, of course, we must do everything that needs to be done. But again, human beings err, and it is much better to go incrementally, step by step, than galloping along and thinking you can make rules when they're not necessary to be made. And I will say that the first court had a lot of debates about incrementality and how much we should do. And sometimes we did decide cases even though we didn't need to. I'm going to avoid citing cases because, I will not be here for 15 minutes if I start. But the one I want to talk about is Du Plessis and de Klerk, which was in the second year of the court, in which the court had to try to understand the relationship between the common law and the Constitution. There was a technical point that meant actually the court did not actually have to decide that question at all. But this was one of those rare moments when the court felt that although we could actually say we're going to dismiss this case because we don't need to get to that point, we will get to it. And I think it was an important case to do that, and it obviously had an influence on the text of the final Constitution. So incrementality is a very important principle, but it's not an absolute one, as the case with many standards is. But I think it frustrated quite a lot of people who were watching the court and wanting the court to do more. But I think it was born out of a sense of modesty, of caution, and of a recognition that it's very easy to get things wrong, and it's much harder to set them right. So it seems to me that those are the first two principles I want to talk about. The third one is respect to the jurisprudence that has already been established. And that meant in the Constitutional Court initially, how do we deal with the jurisprudence that is pre-94? Because of course that was a jurisprudence that had been built on apartheid and apartheid legislation. And again, the court took the very strong view that by and large, as long as the principles were principles that we felt were now consistent with the Constitution, we would not disregard that jurisprudence, and we would rely on it. And we did rely on it in many cases. There were cases, of course, that were beyond the pale, that were clear reinforcements of authoritarianism or racist principles which we wouldn't rely on. But why did it matter that we paid attention to the earlier jurisprudence? And then, in the 30 years since, the court has paid such careful attention to the jurisprudences gone before. It's not because judges are always right or infallible, and we should always assume that everything is right. But it goes back to that first point I made. There are millions of people in our broader society who are looking to see what our jurisprudence is and who are following it. And they're seeking to follow it with respect and integrity. And if we change it, we change what they have to do. And we need to be respectful of, as it were, the guidance that we've given before and not undo it lightly. So I think that is the third principle of how we make a constitutional jurisprudence. And by and large, it seems to me that this is something that has been consistent, really an attempt to try to set principles, determine the content of rights, understand how limitations work, which Justice Wagner spoke about this morning, in a way that is consistent from case to case. And I think that is something of which we should be proud and which really matters. It's not only mattering to lawyers, it's mattering to government, it's mattering to Parliament, it matters to everybody who tries to give effect to this constitutional vision. A final thing I'd like to say about how we do it is we do it recognizing that we are not the only people who are addressing these questions. And this is why it has been so wonderful to have our colleagues from courts across the continent and from Canada and from India here today. The Constitutional Court was enormously blessed to firstly have in the Constitution a principle which said that when interpreting the rights in the Bill of Rights, the court shall pay attention to the principles of international law, the rules of international law, and may consider foreign law, the jurisprudence of other jurisdictions. Again and again in those early years, the court turned to the jurisdiction of other countries and found in that jurisprudence illuminating assistance to guide it. And this is an important point to make. The court looks at the jurisprudence of other countries, not because it considers it bound by them, or because it thinks that they are next-door neighbors, or rich and powerful people far away, or people who have even shared our background. It's because what the courts say in those foreign jurisdictions is reasoned and thoughtful and illuminating. And when it's that, the court has relied on it. And there are numerous cases where the court has drawn on the jurisprudence of courts across the world. In my day, we did not have the African Court on Human and People's Rights. That is a court that has been established in the last, just over a decade ago. But we did have many of the courts that have been represented here today. And I think that this has been an important part of how we build a constitutional jurisprudence. So, in the 30 years since 1995, the court has handed down just under 1,000 cases, 997 on my count. And you will be relieved that I'm not going to tell you all about them today. But what I hope I have told you about is why it's been important that the court has built that jurisprudence, who has built that jurisprudence, and how that jurisprudence has been built. And I wish my colleagues on the current court all speed in carrying this important work forward. I would particularly like to end by noting how moving I found the words of the President in his acknowledgement of the significance and importance of the court in establishing South Africa's constitutional democracy, and that I thought his courageous acknowledgement of how much further we still have to go, how building lives for South Africans that are lives of value and in which their human dignity is acknowledged is still a task we have to do. But I do think that if we all understand what the Constitution is about, that will be a lot easier. Thank you.
Honorable guests, can we take just 1 second and arrange our seats? The sun is burning us. If we can just, OCJ can help us to move away from the sun. Justice Sachs did tell me that he would like to be excused. He's got another speaking engagement this evening in Cape Town. So he is always busy, we know, and we know why. Now that we have been moved, I'd like us now to listen to our retired Deputy Chief Justice Moseneke, who's going to tell us about why this court was an institution and functioned as an institution and not just a collection of legal minds. Let us welcome him. He's here. Thank you, ladies and gentlemen.
When just before lunch, Justice Klichler said to me, "Klein Boet," that's what he calls me when he's in a good mood. That's little brother. All the cliches have been said. I wonder what remains for you to say. You were just around near the last speakers. And for that reason, Madam Program Director, I thought I'd do 2 things very quickly. You still have 5 more speakers to come after me. So I'm going to spare you. I'm going to speak, hopefully sharp, directly to the point, acknowledging and recognizing my 2 very esteemed colleagues who I worked with for well over a decade have preceded me. And you can't do better than RB6, can you? No, you can't. So you have to find Chief Justice a niche. But let me start by thanking you for inviting us here. Siyabulela, Enkosi. And may your stay be long, may it be fruitful, and may you be blessed in all ways that our people and your people know, and may you flourish as you provide leadership as you've done today. So I thought I would rise just to say that, without acknowledging the rest of the colleagues who are here. And again, to thank all the judicial colleagues across the region and across the Indian Ocean, the Atlantic Ocean, who are here. I had the privilege of being guests to Chief Justice Wagner. He put up a lovely lunch in Canada, in his court, and it is lovely to see you here. I and all the other colleagues who are here, I could go to Kenya, Justice Lenyola, I could go to us in Zimbabwe. 4 weeks ago, Chief Justice, and you didn't come to my lecture. I said, where are the judges? I think they thought they were afraid I'll say the usual things I say, that the people be treated well by the judiciary. I thought I would do two things very quickly. The one thing that I thought I would do was to tell you about that conveyor belt that produced these ample judgments that Justice Reagan talked about. There are many other features that one could spend time on, but I just want to tell you the biggest pride I have was how my predecessors worked out a system to produce incredibly high quality and clear judgments that continue to ring not only in this country but across the world. And this is by and large how we did it. I'm going to tell you only about that. And because I hope you will continue the tradition in other forms to speak to our people as you account on how you adjudicate as you do your work. It's how judges account. They have to say why they arrive at certain decisions. I get to court, Chief Justice allocates, together with the Deputy Chief Justice, cases. And each judge, by and large, gets allocated a case for the term. There might be two sometimes, but generally one. And you get allocated cases in which you would seek to assay whether leave should be granted or not. So you would know very quickly by coming to court that it's going to be a lot of hard grind, because leave to appeal at an apex level is a total shut onto the door. So the work always were in tramlines. Should we hear the matter? Should we grant leave? And the other was, what should be the outcome of cases that we have actually heard? The tradition was clear, and I came to know it when I became Deputy Chief Justice and sometimes Acting Chief Justice for long periods. The most complex matters, by and large, have to be taken by the biggest themselves, particularly those which are politically controversial, and the rest will be fed out to the rest of the judges. And there will be a process which is fairly well honed in which justices have to return back in a short while after hearing a matter. If allocated to you, allocation is internal and secret. You will say how you're going to decide the matter and why. And that's in a short note that speaks to all your colleagues. In some matters, it's no problem, but in many other matters, justices would come back and say why they would support the outcome but not the reasoning. Why they would support the reasoning, but certainly not with that outcome, with a different outcome. What am I talking about? It's just the sheer rigor of the early debate in coming to a decision. We are 15 precisely because, are we 15 or 11? We are 15. Huh? We're 11, oh, okay. Now the Germans are 15, sorry, and the Canadians are 7, I think. 9, Canadians are 9. Okay, we're 11, sorry. Now, every one of us is virtually called upon to bring his mind to bear on the issue before us. And we get paid 11 precisely because the public hopes that 11 competent minds would bring to bear their legal and fairness skills in order to produce an outcome. And that was done rigorously, repeatedly, It was almost a big shame that you had no view about any fundamental issue that would emerge as part of a general record. Beyond that point, you would produce a first draft. And it's not unknown that there would be 6, 7, 8 other drafts that would pop up. In Makwanyane, there would have been 11 drafts, obviously. But often the drafts went between 5 and 8, which implied that the cult that had been developed was of industry, of high faithfulness to proper outcomes, and ensuring that each one of us would have an opportunity to be able to make inputs into every judgment that went through. By the time a draft is produced, a time is given by the Chief Justice or Deputy about when comments should come through, and once they've come through, it may be some which are quite substantive, some may be mere language, but by and large it would be the strength and the quality and the rigor of the reasoning that I hope you still feel and sense up to this day when you read judgments that were produced by that court. Having come through and funneled down that way, what remains would then be, provided you have determined where people would lie. Some justices would not vote until the last day, would read through the drafts paragraph by paragraph. And quite often language would matter. And all the jawbreakers would be thrown out of the window and landed very quickly from the High Court. And no Latin you've heard already. And simple, clear language. Strength of the judgment, how it flows and how well it does as it moves on towards outcomes, was incredibly important. If you thought you were done, you've heard my colleague Justice O'Regan talk about, there'll be questions about what does international law say? What does foreign law say? By which we're not bound, but our Constitution tells us to go and look. And that explains, Chief Justice, why so often we got into Canadian jurisprudence, Indian jurisprudence we went to. From time to time to go and look. Because our Constitution enjoined us to do that. So if you produce a draft and you're a judge on the court, and you have not looked around to hear what other minds seized with the same difficulty would have done, you have not done your job. So it's not sufficient, as Justice O'Regan so well put, to rely on your intuition and your internal or domestic or native wisdom. We want to know what other people have done who are much older and who have been around to deal with these issues of society. Beyond that point, each of the justices would come back and say, I'm coming along, and many others quite often would write dissents. I wrote the first judgment, State versus Stevens, on common purpose. How many judgments were written? Easily there were like 4 or 5 judgments, and I managed to draw the majority because the Chief Justice Chaskosen came along with me. And the words started becoming a little better, but that was my baptism of fire. So I'm trying to make a point, which really is that an incredible culture had been built of industry, of consistent work right through the year in every judgment, of fulfilling the promise that 11 people would test and look at whether there is relief that might emerge from a particular dispute, and took seriously the notion that that is the only real method of accountability. And in no time the people of this country caught on to that, read our judgments, and were the biggest defenders of the Constitutional Court in times of crisis. So the more you drift away from the people, you're not likely to have defense, particularly when the members of the executive here. When members of the executive start raising their heads and trying to be impatient with us. I thought I would make that point in a hell of a rush. Most of them were made about intellectual rigor, about plain language, and then the second, about collegiality. Be respectful to colleagues even when you are in deep disagreement with them. In fact, the more you disagree, the more humble and collegial and pleasant you ought to be, without giving up the fact that you actually have a fundamental difference That we were taught by all of the civility was there for. I've talked about comparative law, and I've talked about law clerks and researchers, from whom you're going to hear very shortly. They're very important people now, but both were trained in that cauldron of training where we have young people come in every year. Every single year there's an intake. You have 12 months in which to work with us. Let me say immediately, to disclaim immediately, clerks don't write judgments. We only write our judgments. There is a culture in the court, and long may it live, long may it persist. Do they debate what possible outcomes there might be? Indeed they do. And if you forward one slide, the two on my right, they're probably going to try and tell you exactly how the outcome should be. But they're welcome, they're wonderful, they did most of the research. They found foreign law, they found international law on which we could rely. And they've become a great boon to this country. Most of the activism, most of the excellence. And before I leave this, we are blessed with a very active bar. Civil society you heard from, but incredible. And you're going to hear both from Advocate Trango and Advocate Marcus shortly about their roles. I don't think any of these outcomes, any of this legal, any of the jurisprudence that we have been talking about the whole day would have been possible without the excellence that was brought to bear by the bar, which continued all the time to make presentations and to research in order to help update the law. For that, I'm internally grateful. And I want to make the point also that my colleague Kate Reagan made about the academy. That cross-pollination between the bench and the academy. There were journals which were dedicated to critiquing judgments that we wrote. I praised them or to condemn them. And it happened so helpfully because it meant that the taxonomy, that is the strength of the academy, would be incorporated into our writing, into intellectual rigor that we needed so much to be the court that you all talked about the whole day that would be. My parting words, Chief Justice. You're running a very important institution. This morning I looked up the wall. Only 4 of us remain, Kate. 7 of our colleagues have passed on. From the Magnificent 11, as I call them, you've heard about all the wonderful work they did to produce, and Justice Yakub, myself, and Justice Nobo at the second intake, as Justice Fichler, Justice Goldstone, and Justice Ackerman retired. And we came in as sort of a young cavalry that Arthur went out to go and look and to make sure that we come and join his team. So we must be grateful to them. And all this culture I've been talking about, they inducted. Including the culture that nobody goes away during term. All hands on deck, Chief Justice. Everybody works during term. And when you go away in recess, you need to give us our particulars. It's only Albie Sachs who we couldn't track because he was going all over the world. So you wouldn't know if you have an urgent where you'd find him, but he had to file his itineraries every time because the court could see just about. So industry and intellectual rigor and a deep sense of justice and accountability to the people set central to this enterprise. So, Chief Justice, there are barbarians at the gates. There are people who increasingly say that the Constitution has failed. There are people who increasingly suggest that we again need parliamentary sovereignty. Because they, the politicians, will deliver to the people, and they can't now because the judges stand between them and the public goods which are so sorely needed by our people. Judges are not elected, but they sway more power than elected people. who hit the streets to canvass in order to be voted into office. So the barbarians are truly at the gates. And by that I mean people who actually don't fully appreciate the importance, the extent of the edifice that we have built by way of a constitution with the new judicial structures and culture. I've talked a little about it. My colleague Albie Sachs talked about it, Cato Reagan talked about it. We should resist that. We should make it clear that they are the ones who have failed to deliver the goods, public goods that are sorely needed by the people of our country. And that we have pointed them without fail all the time to what they must and have to do. And they haven't often done it. And in order to make sure that our institution continues, and so I hope, Albie says will be here in 30 years, I don't think I'll be around. But we should continue to protect the institution. I know you. It's going to happen outside all the noise that's been made every day. Give me the power, and I will make your lives better. Everything we need to make our people's lives better, we have. We need dedicated leaders in other parts of government, and we need a judiciary that is forever abiding in order to protect all these gains that we have made over the years. And our colleagues who follow on, I know you take this seriously. And each time I look at the young advocates who are doing their thing out there so competently, I know that we are in safe hands. And Chief Justice, I've tried to be as short as I can, so that you can find your own chance very shortly to do your thing. But that's all I really wanted to say, and hope that we keep on and we reject any notions that we have been the bad part of this exercise. We've been the best part of the exercise. But we must continue to be. Thank you.
Thank you, retired Deputy Chief Justice. The retired Deputy Chief Justice and Justice O'Regan have already told us how this court leans heavily on their law clerks in the process of ensuring that the judgments of this court are as groundbreaking as they always are. Yes, they are always groundbreaking. We have invited two of those who joined the court during the first decade. They are here, and the retired Deputy Chief Justice has already said that they are in great places. So it pays to be a law clerk in this court. The first I'd like you to welcome is Advocate Ngugaitobi, SC. He will be followed by Ms. Repkin after that. Thank you.
Thank you, Justice Chico. I was a law clerk in 2001. I had interviewed for that job with Judge Arthur Charles Kalsin, Judge Cato Reagan, not sure if you still remember, anyway, and Judge Sandile Ngcobo. Clearly, neither Judge Ngcobo nor Judge O'Regan thought anything of my application. It was only Arthur Charles Kalsin who did make me an offer as one of his two clerks. But I also remember during that interview that I probably made a fool of myself, because I fiercely defended the judgment of Dennis Davis, Judge Dennis Davis, in Groot Boom, saying that everyone has a right to a house by the state on demand. Now, after a long debate with Arthur, he finally asked me if I had bothered to read the text of the Constitution before that, of Section 26, before defending the judgment. I can't now remember my answer to that question. But yet Arthur still thought he could take a chance with me. You see, this is important because we assume
that individuals come fully prepared, fully ready, and fully able and fully formed. Yet if we take a chance to each individual, someday, one day in the future, that potential could turn into success. Shortly after we started as clerks, the law clerks community mandated me to speak to Arthur about the critical matter of the wages or the salaries of the clerks. You see, we were appointed with effect from the 15th of January 2001. When we received our salaries on the 30th of January, we discovered to our shock and horror that we had been short paid. I made the argument on behalf of the clerks community to Chancellor that our salaries were short by half. And this is the conversation that ensued. It's a real story. It happened thereafter. Arthur says to me, how many days do you want to be paid for? I say to him, 30 days, because the contract says we're entitled to monthly payments, and a month is 30 days. Arthur then says, how many days have you worked? I say to him, 15 days. That was the last time we had that conversation. Later that very day, Arthur came back to my office with his customary hands on his chest like this. He says to me, Tembeka, do you have a cash flow problem? Because really, if you do have a cash flow problem, let's talk about that. I think I said to him, no, I didn't have a cash flow problem. Although I had no transport money that very day. Takes me to my second point. I always felt that there was something about the judges of that court, exemplified by Charles Carlson's cross-examination of me, but then the later visit to my office. It's a spirit of Ubuntu, I think. These judges tended to be very generous, and they tended to have boundless humanity. Our role as clerks, certainly my role in my chambers, or I didn't have chambers. Arthur's chambers, but we called them our chambers, you know what I mean. Was to prepare memoranda, particularly on applications for leave to appeal. It was a bane of our existence, particularly in the criminal courts. And most of those transcripts were in Afrikaans because we were still transitioning. And it was also to conduct legal research, to prepare memorandum on identified questions of law. And then it was also to site check, which is the checking of the corrections in the judgments. And that was probably the biggest portion of the work that we did. And no, Deputy Chief Justice, I didn't write any judgment. See, many clerks, they say, no, I wrote that judgment. Anyway, I was not that lucky. Yeah. But I remember in this context that I cited 3 judgments in a footnote in a case called Van Rooyen, as Minister of Justice. I think it was about the constitutionality of some of the amendments to the Magistrates Act. Yes. And then I gave my memorandum to Arthur. And he then noticed that I had cited his 3 judgments, but it was on a trite point, like Audi Alteram. He then said, I see you have included 3 judgments on your note. What do they say, and what are the facts in each? Now, I told him, quite frankly, that I had found the judgments in a legal article and had not actually read the judgments. He just gave me the look, and that was the end of that. But I learned a lesson. Never cite a judgment without reading it. Although we still do. Sorry, we don't. So beyond the
relationship with my judge. That's how we call them my judge. We were also able to form new friendships and lifelong relationships with other clerks. And those became a community of friends, particularly from someone like me, who came from a rural university and came from a village. And really Johannesburg was my first opening into the big city. I remember Susanna Cohen, I think was the clerk that came in the year before me, clerking for Charles Wilson. She's now Deputy Judge President in the Land Court. I remember Rwandile Sisilana, who I think had clerked a year before me as well. He's now Senior Counsel at the Bar. I remember Stephen Butlander and Nazrin Rajab at the time, who came after me, and they have been incredibly successful lawyers. I remember, I think Kate Hofmeyer came afterwards, after Stephen, and Adrian Friedman. I remember Pule Seleka, who was my co-clerk, who is now the chairperson of the Legal Practice Council. And of course, Freda Rapkin. We were in the same year directly. And she's now the great legal journalist of our country. Of course, I remember Silo Chilwane, who I saw here, who now works in the government bureaucracy. Doing a great job, by the way. Doing a great job in the government bureaucracy. We need people like him working for the state. I just mentioned these names because they have come to play important roles in the judiciary, in the legal profession, and in the state. They've also come to be pillars of championing constitutional values and also champions of strengthening the democratic state and helping us to navigate the treacherous terrain of how to overcome the apartheid legacy that has been left to us. So the court has been training ground for us, and it gave us experiences that we could never have got in any university, no matter how long. But I also remember the judges. Johan Kriegler, saw him here. I remember writing his name incorrectly, missing out the N, and then he said, there are two N's, blame my father. And then he would say, kids, listen to me now. I also remember Sandile Ngogo, who used to walk down the passages in Brown Park, whistling around. And in legal argument, he would say, well, Mr. Trengove, hang on, before we adjourn. I also remember Yvonne Mohoro, who is the only person that I know who had met Robert Sobukwe in person. I also remember Laurie Ackerman, who would say, well, that is not the German experience. And Albie Sachs, who tried to find the human spirit behind every cold word of the Constitution. I also remember Mrs. Sharon Lutuli, who was in the library and teaching us about how to research. So Chief Justice Maya, I have been talking about really anecdotes about my experiences in the formative years of myself, and it turns out the formative years of the Constitutional Court itself, the first 10 years. Obviously, since then, I have done many other things, including representing a former Chief Justice. I won't say his name. Anyway, everybody knows it was before the court. But I've done many things since I left the court. But there's something unique about that experience that has stayed with me, because it was the most transformative, not in my legal career, but in my life. So someone like Arthur Charles became a mentor beyond my time at the Constitutional Court. So I also keep asking myself why that year has remained etched in my memory as a human being. Perhaps it was the culture of the court which Arthur spearheaded. The culture of inclusivity, of Ubuntu, of empowerment, of standing up against injustice, but also of being aspirational, that the future will be better than the past. So Arthur knew that he had no control over the judgment of his colleagues who could control Kriegler, control Sachs, or control Ackerman. No one could control those minds. But what he could control is the culture of the court that he was building. That depended entirely on the leader. So the next 10 years, Chief Justice Maya, are for you to build a new culture according to your own evaluation. To build a culture that will elevate the standing of the Constitutional Court, that will entrench the respect of the court, but it will also entrench the respect of the law. I had a conversation with Arthur Charles Carson when I ended my clerkship. He saw the court as an evolving institution, reflecting the new demands of the new society as the society itself evolves. That evolution has now entered the 4th decade. But it is now driven by a different driver, no longer by Arthur Charles Carson. But Arthur never saw himself as the sole and the only driver of that project. He thought of himself as an enabler for future Chief Justices. So Chief Justice Maya, the next 10 years are under your leadership. We want to come back and reflect on those 10 years with the same admiration as we do about the first. Thank you, everyone.
Thank you, Advocate Mugai Toby. Ladies and gentlemen, let us welcome Ms. Repkin warmly.
Afternoon, everyone. That was my co-clerk. He doesn't know it, but when we clerked together, behind his back, we used to call him Chief Justice of the Clerks. And you can see why. He was our leader even then. Thembeka was telling you about his interviews. I'm in two minds about whether to tell you about my interviews, because they were even more embarrassing in some ways than his interviews. My first interview was with Justice Ackerman, and I was so nervous, kind of like how I am now, that when I walked into his chambers, I explained to him his own judgment, forgetting briefly that he penned the judgment. And when it occurred to me that I am talking to the judge who wrote the judgment that I am explaining, I got so distressed that I couldn't say much anymore. And when I walked out of there, I thought, okay, I'm not getting this job. Luckily, I had 3 other interviews. I don't know if they went better. I think at least my interview with Justice Langa, who was my judge in the end, must have gone a bit better than that one. Chief Justice, thank you very much for inviting me to speak today. I confess, when I got the invitation, I was overwhelmed. I couldn't work out, and I still can't, why I, of all the former clerks of this court, was asked. I'm a journalist. There are so many other former clerks who seem to me to be much more obvious choices. There are clerks that have gone on to be judges. Some of them are here today, even acting judges of this very court. There are esteemed silks, there are academics, there are senior partners at law firms. There are some who joined the civil service. Thembeka mentioned Sidlo, who was my co-clerk as well, to build our country. There are NGO practitioners who have made immense contributions to our country and changed the lives of many people. And when I was trying to list in my head all the other people the Chief Justice could have asked to speak here today, it really made me realize just how many extraordinary lawyers, but more importantly, extraordinary human beings, began their careers at the Constitutional Court. There are generations of them. And this is not a coincidence. And I've been thinking about why. What is it about the Constitutional Court? The Constitutional Court is not a perfect court. I don't think there is a perfect court. It is a court in South Africa, for one thing, and our challenges are many. In the Azapo judgment, Justice Mohammed quoted Kant to say, "Out of the crooked timber of humanity, no straight thing was ever made." This court is a very human court, with all that brings. Its humanity makes it imperfect, but its humanity is also what makes it special. A court is many things. It is a building, and we heard about the building. It is an institution with an institutional culture. It is a body of work, a jurisprudence. It is a group of people, judges and staff. This court is all of those things, yet it is more. I clerked at the court in 2001 and 2002. My judge, we always say my judge, we are very possessive over our judges, was former Chief Justice Pius Langa. Then he was the Deputy Chief Justice, and the court was still at its temporary home in Brown Park. I was thinking, looking back at for some memories that could really distill what was so special about that year and a half that I was at the Constitutional Court. And the one that came back to me was I think in the first 2 or 3 weeks, my judge came and greeted me in my office. He said to me, "How are you today?" I said, "I'm okay, Judge. I'm a little tired." He said to me, "There's no such thing as tired in our chambers." And I was never tired again. So we learned about hard work in that court. And, you know, it was a very exciting time. The President mentioned the TAC case. We were there for that case. But the case for me that really I hold close to my heart, because I'm a journalist, was the Islamic Unity Convention case. You know, when we were registering or getting ourselves accredited, I was walking out of the court building, and there was a protest outside. And I briefly listened to what the people outside the court were protesting. And a woman said, "This constitution, they're not doing it." And I thought to myself, I love this court. We are celebrating the Constitutional Court, and there are people protesting outside the Constitutional Court. This is the right to freedom of expression. And I am a journalist. The right to freedom of expression is of daily practical relevance to me every single day. Their right to protest is my right to write what I do. And the fact that we are here today with that protest happening, celebrating this Constitutional Court, I felt somehow it was all connected. And it says something about why this court is so special. And every time I read a judgment or court papers that cites that judgment, because that was my judge's judgment when I was clerking for him. And yes, we don't write judgments. I've never written a judgment. But I feel a special sense of ownership over that judgment because, I don't know, I contributed a little bit. I was there. I side-checked the judgment. And because it's a freedom of expression judgment. But still, it's hard to really pinpoint what was so special about that time. I agree with Tembeka, it was a life-changing experience for me as well, and I think for many former clerks. I feel like I was raised by the Constitutional Court in many ways. And there's something almost intangible that it's difficult to put your finger on what it is about it. And I think it has something to do with the example set by the judges of that court at that time. It was something to do with how they saw the litigants before them, how their humanity and their life experiences, or I suppose their dignity was put front and center in every case. but also how they treated each other, how they dealt with each other, how they dealt with us, that really set an example. There was no one saying you must be like this and you must treat people this way, but by example, we absorbed that, I feel. And I must also say that there was something very special for us as young women lawyers to have Justice Mokgoro and Justice O'Regan as judges of the court in our first jobs out of university and seeing them being so excellent. I used to sit, when we sat in front, you know, the clerks sit at the front, I could always tell who was an experienced counsel by how they reacted when Justice O'Regan would say, I have a difficulty. If they were an experienced counsel, when Justice O'Regan said, I have a difficulty, they would take a deep breath. They knew it was the question was coming. If they were a little less experienced, they might smile indulgently and think, tell me your difficulty. And those were the ones who saw flames. They would be in trouble. So, you know, I've completely gone off my written speech, and now I have to come back to it, and I don't really have time. But what I had originally wanted to say is that I was lucky as a journalist because I stayed close to the court. I've been reporting on it since. And I'm going to... How much time do I have? Not much. Okay. So let me then, maybe I'll publish this as a column. I will, just to say, I had some stories I wanted to tell about different judges of this court and things that I had seen them do in my time as a journalist, and what they said about what I wanted to point to about what was so special about this court. Because what I really feel as I've watched this court grow and develop is the way in which it has occupied the minds and hearts of South Africans. We as journalists are out there and we see and talk to people. And this court has a special place in our country's public mind. I think it has become the conscience of our nation. And as I stand here today, 30 years on, it's a real honor that I was there just for a little while. It's an honor to carry on telling the stories of this court. It's a particular honor to do so when we have our first woman Chief Justice. And I am grateful for this opportunity, and let me leave it there. Thank you very much.
Honorable guests, it's been fascinating and challenging. We can only thank the retired Chief Justice, the Chief Justices of the court and the Chief Justices for having paved the way for us. We are really, really thankful to you. And we are thankful to the law clerks as well, who have paved the way. At this stage, in conclusion, I'd like to call upon our acting Deputy Chief Justice to share how the court has navigated the perils and imperatives of the separation of powers. A very difficult topic. Let us welcome Acting Deputy Chief Justice, Acting Deputy Chief Justice Madlanga. Warmly.
Let me greet everybody once again. Good afternoon. Let me start with a question. Does the Constitution make provision for the principle of separation of powers? If you troll the Constitution from beginning to end, nowhere will you find reference to the principle. And yet, it is firmly embedded in our constitutionalism. Where then does it come from? The existence of the principle in our constitutional order was heralded by the constitutional principles that were contained in Schedule 4 to the interim constitution. These principles were agreed upon in advance by the parties that reached the negotiated settlement that resulted in the interim constitution. Through Schedule 4, the principles became part of the interim constitution. In the first certification judgment, the Constitutional Court held that the principles set parameters that were to be a guide on the content of the final, that is, the present constitution. It was obligatory that these principles be adhered to in crafting the final constitution. They were thus foundational to the final constitution. The relevance of all this is that Constitutional Principle 6 envisaged separation of powers. It provided that there shall be a separation of powers between the legislature, executive, and judiciary with appropriate checks and balances to ensure accountability, responsiveness, and openness. The Constitutional Court was to be the final arbiter on whether there was compliance with the constitutional principles. In the second certification judgment, the Constitutional Court certified that the provisions of the amended text of the final constitution complied with the constitutional principles. What this means is that, as required by Constitutional Principle 6, the final constitution was held to provide for separation of powers. It is idle, therefore, to want to find a provision in the Constitution that specifically refers to separation of powers. The structure of the Constitution delineates the functional areas of the three arms of state in a manner that recognizes the separateness of these arms. What I see as the greatest threat, not just to the proper functioning of courts within their delineated constitutional mandate, but to the trust and confidence they enjoy within the public, are unfounded allegations of the so-called judicial overreach. Judicial overreach is said to comprise breaches of separation of powers that entail the unjustified invalidation of laws or government policy. Over the years, courts have faced bold and populist allegations of overreach. These accusations have been made a number of times, and quite often they are made by people in political office or aspiring to it. In other words, people with skin in the game. The accusations include the following: A, that the courts are acting as if they were the political opposition and in so doing, seeking to arrest the functioning of government. B, that we are government and the judiciary is not a government and it cannot simply review all government policies. They cannot be elevated to do something they are not supposed to do. C, that the republic was being made into judicial dictatorship by a coordinated liberal offensive against almost any decision by the president and the executive. D, that the courts are composed of, in part at least, counter-revolutionary forces, there being a drive in sections of the judiciary to create chaos for governance. Of course, courts are not beyond reproach. Like any institution, they must be criticized, not least because the Constitution guarantees the right of freedom of expression, but also because for any institution, including the judiciary, constructive criticism may result in introspection, which in turn has the potential to improve output. So, I welcome constructive criticism of the judiciary. It fosters the values of openness, accountability, and responsiveness, which are foundational to our Constitution. As Grifla J. held in Mamabulo, this openness seeks to ensure that the citizenry know what is happening such knowledge in turn being a means towards the next objective, so that people can discuss, endorse, criticize, applaud, or castigate the conduct of their courts. And ultimately, such free and frank debate about judicial proceedings serves more than one vital public purpose. Self-evidently, such informed and vocal public scrutiny promotes impartiality, accessibility, and effectiveness, three of the important aspirational attributes prescribed for the judiciary by the Constitution. Often, criticism leveled at courts is not constructive. The danger is that such criticism is often made from platforms that have a wide public reach, sometimes by people who enjoy public influence. Needless to say, that has the potential to have a deleterious effect on the judicial function, on the trust and confidence that the public has in the judiciary. Whittle those away, you whittle away the very substratum upon which the judiciary and its functionality are rooted. Some of the uninformed criticism leveled at courts is rooted in the idea of counter-majoritarianism. That is, the idea that, not having been put in power by popular vote, courts have no business in validating enactments of a legislature that has been voted into power by the majority. A question that arises is, how far can the counter-majoritarian argument go? I must observe here that retired Deputy Chief Justice Moseneke did touch on this subject. In the very first section, parliamentary supremacy is supplanted by the supremacy of the Constitution. The effect of this is that all law that Parliament makes is now subordinated to the Constitution. It is the courts that have been made arbiters of what is constitutionally compliant and therefore acceptable in the eyes of the law. The reversal of parliamentary supremacy is complete. The counter-majoritarian argument has troubling implications. It implies that judges must leave the executive and parliament alone purely on the basis that they are in power as a result of majority vote. Yes, courts must not interfere in that sphere of operation that is a constitutional set-aside for the executive and the legislature. Otherwise, they will be breaching the separation of powers principle. That said, courts are the final arbiters on whether the executive or legislative power has been exercised in a constitutionally compliant manner. Within those parameters, there should be no cause for complaint. South Africa is a democratic constitutional state. For as long as that continues to be so, that is the position courts will hold within the balance of power. And that will go a long way towards guaranteeing a healthy, functioning separation of powers. As seats on the judiciary are occupied by fallible human beings, those human beings will err at times. Their errors cannot be confined to any one facet of the area of function of the judiciary. What that means is that some of the errors may involve straying onto the areas of function of the other arms of state. I mention this to sensitize us, the judiciary, to the reality that we may err, and err in a manner that encroaches on the functional area of the other arms of state. Hopefully, that will help towards guaranteeing that we stay within our lane. We are in the fortunate position that the other arms of state respect our pronouncements. This is the case even in instances involving highly charged and emotive political issues. However much political sentiment may have been leaning away from the direction ultimately taken by a court decision, the immediate official reaction from the executive and legislature has always been that the decision will be respected, subject perhaps to the al-Bashir matter. So, on this front, there is nothing perilous. It is a sign of the strength and vibrancy of the constitutional order. President Ramaphosa this morning mentioned that there are times when there is non-compliance with court orders, but my sense was that it was not a case of either the executive or the legislature saying, we are not going to comply with those orders, but perhaps more being a matter of implementation and failure to act on time. I doubt that it's instances of we are just not going to comply with those orders. It behooves us as the judiciary to dispense justice in a manner that engenders public trust and confidence. With that trust and confidence in place, our decisions will command the respect of right-thinking members of the public. After all, that trust and confidence are all we have. Let me close with the words of the late Chief Justice Ismail Mahomed, who, speaking extra-curricularly, said, "Unlike Parliament or the executive, the court does not have the power of the purse or the army or the police to execute its will. The superior courts and the constitutional court do not have a single soldier. They would be impotent to protect the Constitution if the agencies of the state, which control the mighty physical and financial resources of the state, refused to command those resources to enforce the orders of the courts. The courts could be reduced to paper tigers with a ferocious capacity to roar and to snare, but no teeth to bite, and no sinews to execute what may then become a piece of sterile scholarship. Its ultimate power must therefore rest on the esteem in which the judiciary is held within the psyche and soul of the nation. That esteem must substantially depend on its independence and integrity. Thank you all.
Thank you, Acting Deputy Chief Justice. Ladies and gentlemen, we promised a Q&A session, but because of time constraints, we cannot be able to do it, and I apologize for that. This concludes this specific session. There's another session that is going to follow. Please bear with us. Let me thank all of you for participating, and you've been a good audience. Thank you.
Just a brief thing that I must share with you. I was present on that memorable day in February 1995 when the first judges were sworn in. I was a young lawyer then, and I looked at them in awe. It would have been in my wildest dreams to think that I would one day be part of this court. And as the clerks said, it's an experience that changed their lives. it's an experience that changes my life every day. So thank you for your patience. We've run slightly over time, but I hope in turn what we've given you is a day full of richness, full of warmth that's made this chilly day, and it's filled us with a sense of really pride at being South African. So I'm sure you're willing to continue indulging until not for much longer. So we have two sessions now. The first is really just looking at Makonyane, and the Chief Justice has spoken about Makonyane in her speech today, because more than a case about the death penalty, it's a case really to find who we are as South Africans, what our relationship is with each other. And we managed to assemble part of the team that argued the case in 1995. And that will be followed by an issue that the President has spoken about as well, the promise of the Constitution in socio-economic rights promise, and Professor Liebenberg will speak to that. So it's going to be a rich session, and everybody's agreed to keep the time limit. We don't need a comment. So, counsel for the applicants will kick off, and then, but they will not re-argue the case. So, you and Gilbert.
Justice Meyer, thank you so much for inviting me. I have, of course, often addressed you, but it's a delight to know that this time you won't deliver a public judgment on my performance. On that day, on the 15th of February 1995, I had the extraordinary and once-in-a-lifetime luck to be the first advocate to address the new Constitutional Court. My abiding memory of that moment when I rose to address the court was of a bead of cold sweat running down my spine, which I've subsequently learned quite accurately is apparently a fight or flight symptom of acute distress. Anyway, it was a fantastic occasion. It was a wondrous occasion with a new democracy, a new constitution, a new court, a new law, and new judges, a galaxy of superstars of the law in South Africa. So it was an extraordinary occasion. But it was also a very, very serious occasion. It's easy today, with benefit of hindsight, to say we knew that the death penalty would go, but that wasn't so at the time. And let me remind you of the history. The government on the 2nd of February 1990 imposed a moratorium on the implementation of the death penalty. Not on its imposition, judges continued to impose death penalties, but on its implementation. Now let me just give you an idea of what that meant. In the 5 years before the moratorium, South Africa had executed 657 people. 657 people in 5 years. That is 131 people per year, more than 10 people per month. Those people who had been on death row on the 2nd of February 1990, plus all of those who received the death penalty after that date, had accumulated by their hundreds in death row, and their fate depended on the outcome of this case. So it was not only a wondrous occasion, it was an extraordinarily serious occasion. Everybody was on edge. All of us, obviously. Well, we're always on edge when we appear before the Constitutional Court. But on this occasion, even the judges were on edge. I remember at one point, the judges sat in a half moon. One of the judges at one end of the half moon asked me a question. But before I could answer, another judge on the other end of the half moon jumped in and said to me, "Mr. Tengo, can you tell me of what possible relevance that question is to this case?" Oh, what do you do? What are you meant to do as an advocate? Yes, on the one hand, but on the other hand. So we weren't the only ones who were stressed out. The argument went reasonably well, but perhaps not as well, I discovered later, as I thought it had been, because one of the arguments I made was a well-established fact in the abolitionist cause, that it has never been proven that the death penalty has ever prevented a murder that a life imprisonment would not have prevented. In other words, it's never been proven that the death penalty has a marginal deterrent effect above any other sentence. And so I made that argument. I thought a persuasive argument. But a few weeks later I bumped into a friend of mine who said, you know, when you made that argument, I was in the back of the court. And I wanted to jump up and say, me. Because if it hadn't been for the death penalty, I would have murdered that ex-husband of mine. Anyway, the argument went better than she thought it deserved. And by June that year, the court delivered 11 judgments. Now, advocates like to win cases, but 11-0 is better than any other. But let me say this, it was not only nice to win 11-0, it was also a spectacular demonstration by the court that each one of the 11 judges thought it important that their voices be heard in this chorus celebrating the new democracy, the new constitution, and the new law. So it was a wondrous experience, and I thank you for it.
Thank you, Advocate Gilbert.
Chief Justice Meyer, I cannot tell you what a relief it is to be able to address you and other members of the court without beginning, I appear on behalf of. Early in April 1994, I received a telephone call from Carmel Rickard, who was one of the best journalists in the country. She wanted to know when the constitutionality of the death penalty was likely to come before the courts. And of course, the elections were weeks away, and they were due to usher in a revolution to our legal system. So I advised her to phone the registrar of the appellate division in Bloemfontein, find out what the first death penalty cases were that had been set down after the 27th of April, and have a word with the lawyers and ask the lawyers whether they would be raising the Constitution. She phoned me a few days later in a sense of shock. She had done as I had suggested, but she told me that when she asked the lawyers whether they would be raising the Constitution, the reply she got was, "What Constitution?" I relayed this all to my friend and colleague Wim Trengove. Wim took the matter up with the Pro Deo Committee of the Bar Council. The first death penalty appeal was set down in the appellate division on the 3rd of May. It was State versus Makwanyani, a gruesome multiple murder case. And in the result, the Pro Deo Committee appointed me, Wim, and Herman van Vuren as Pro Deo counsel. We faced many challenges. Debates around the death penalty, the morality of the death penalty, had raged for centuries. The literature was vast, but there were actually very few cases in which courts had struck down or dealt with the death penalty in other jurisdictions. Many countries had abolished the death penalty, but that had been done by the legislature. The jurisprudence of the United States did us no favors whatsoever, and dare I say, neither did the jurisprudence of the Indian Supreme Court. So literally everything about the case from a constitutional perspective was a clean slate for us. We thought, that's Wim and I thought, we knew a bit about constitutional law. Wim had read Lawrence Tribe's massive textbook, probably more than 1,000 pages on American constitutional law, from cover to cover. He was probably the only person in the world who had done that, apart from Lawrence Tribe himself. I had co-authored a book on the Bill of Rights, or the pending Bill of Rights, together with Azar Kachalia, Dennis Davis, Fink Haysom, Helton Cheadle and Penwell Maduna. It had a short shelf life because it turned out that a lot that we had written was wrong, and in any event, the Makwanyane judgment rendered it redundant. At some point, Wim thought it a good idea that our clients should be told about their enhanced legal team and about the fact that their case was going to be the historic first case in the new Constitutional Court. And so he dispatched Herman van Vuuren to Diepkloof prison to tell them the good news. Herman returned ashen-faced. He said the clients were not happy. I said, are they not satisfied with the new legal team? No, that wasn't the problem. The problem was, as Wim had pointed out, that the moratorium would come to an end and their fate would no longer be put on hold. So the seriousness of it had finally dawned upon them, and in a fundamental way. Looking back on our heads of arguments, I think the courts today might raise their eyebrows. We took a few liberties. They were 90 pages long. We put up about 60 pages in reply. We wanted to say something about the cruelty of death by hanging, so we simply annexed an article published in the Rand Daily Mail about what happens to the human body when it is hanged. It happened to have been written by Chris Barnard, the heart transplant pioneer, and he cracked a mention in one of the judgments. And then, of course, the Attorney General, unsurprisingly, placed huge reliance on the American jurisprudence. Didn't know really what to do. What we ended up by doing was we solicited an opinion from leading American constitutional scholars from the NAACP and Human Rights Watch, and we simply annexed it to our replying heads. We did so on the basis that the American jurisprudence on capital punishment, and I'm quoting from our heads, leaves much to be desired and should not be emulated. And in any event, we thought far better to get experts from America than rely on submissions from the Attorney General. Probably the biggest challenge facing us was the bench. This was an appeal which was set down for 3 days. The bench consisted of a group of extraordinarily strong-minded individuals who were frankly ungovernable. At the end, Wim and I were agreed that we gave the bench a very good hearing, particularly Justices Mohammed and Justice Didcot. The judgment in Makwanyane cemented the position of the Constitutional Court on the international stage, and rightly so. It was an immense privilege for me to appear in that case, as it has been in every case in which I've appeared before the Constitutional Court. Thank you.
Thank you to both counsel who appeared for the applicant. Appearing for the respondent and part of the team is now acting Judge Bika. She was led by Attorney General Klaus van Wilson-Vulkau and Tim McDally. So, please.
Behind this. So somebody can move this for me. I'm fine, thank you. When I look back on my legal career, which is now 40 years, maybe more, and maybe I'm giving my age away, being in the first matter in the Constitutional Court must surely be the highlight. And Chief Justice Maya, Acting Chief Justice Madlanga, thank you so much for this opportunity. but I'll get back to you in a moment, Justice Madlanga. Justice Maya, an inspiration to every little girl who wants to be a lawyer and knows that they can get to the very top. Me included, may not be a little girl, but I know I can then get to the very top. Justice Madlanga, when I was given the invitation, I was told, talk about the judgment. And I thought, oh my God, all these chief justices and legal heavyweights, you want me to comment? And then you saved me. You then said, talk about my memories. And I think maybe that's what we need at this time of the day. I'm standing here representing the respondents, but I did not actually argue the matter. I assisted to formulate the heads. We were 10 people, and it was an esteemed, talented group of advocates. Was the Attorney General, who was my immediate boss, Advocate von Leers and Broekau, the Attorney General in KZN, then Attorney General of Natal, Tim McNally, and then a Deputy Attorney General in our office, Advocate Henning, who was an SC at that time, and then there were 7 more of us, me being one of the junior ones. And I knew that what we said or did that day was going to have a profound and lasting impact on our legal system. And I must confess, I was secretly glad that I didn't have to stand up and face the 11 judges. I'd been to court with 1 judge, 2 judges, 3, even 5, because I'd been to the Supreme Court. But 11, it made me feel faint, even feel faint as I stand here now. I couldn't do that. But anyway, we went in knowing that there was a good chance the court would rule against us, but we put up a valiant fight. We knew that the Section 9 of the Interim Constitution protected the right to life, and the death penalty could not be sanctioned. And, as my colleague had mentioned earlier, since the last execution had taken 6 or 7 years, had been done 6 or 7 years prior, in the 14th of November 1989. But when we did get convictions in murder matters and did get the death sentence, we felt that we were doing our duty to the citizens, because we had families of people who had been murdered, whom we had to face, and we had to answer to, and we saw the anguish that they went through. And what most people, I think nobody knows this, we almost did not even appear to argue the matter. What had happened was, the notice, since it had come from the Constitutional Court, who knew what it looked like? And it had come with no fanfare. Not like we had a separate section for the things that came from Bloemfontein. So we knew, as Edward von Leers would say to us, make sure this gets answered on time. This thing came in, lay in somebody's office. She had dealt with the trial, a junior advocate, lay on her table for a few weeks. We almost did not even appear. Anyway, when it came to the Attorney General's attention, of course we all had to spring into action, and we did. All of us rushed around, and he grabbed us and told us what he needed us to do. And like I said, even though we knew we may lose, the Attorney General was having none of it. And all of us were prosecutors at heart, and we knew we were going to argue this the best way we could. So we set about writing the heads, assisting him with all the research, and as counsel mentioned earlier as well, we had no constitutional court precedent in this country. And we were so isolated for so many years. We weren't even allowed to refer to judgments in other courts. But now, the interim constitution said you must do that. Where to find those things? These are the days of no Google, very little Nexus, and definitely no Safri. So, no sitting on your phone and saying, death penalty. I had to trudge to the university. I was then sent to the University of Witwatersrand. I don't think I even had a car then. Probably walked across the Queen Elizabeth Bridge and went to the university and read up on the Canadian gentleman, on the Canadian law and the Indian law, because their constitution we had based our constitution so much on theirs. And so their precedent was going to help us. Others went to the UNISA library, others went to UJ library, and then literally just sat around reading books and writing as much as we could for writing the head, to compile the heads. And then we did that, and we got it all together. And then, because once again, no case lines, what happened was there were 11 judges, 11 law clerks. Each one wanted their own file. Now what were we to do? We couldn't just send our heads. We had to then get copies of every single case referred to, because they wouldn't have access to it. We made Leeuwenhoek files that size, 22 of them, and then 3 just for show. They said to us, if you go back over and look at the notes, they told us 25 of those. I'm sure we emptied half of the Amazon forest with all that paper. How to carry it? What were we to do? One of the advocates had a bakkie. We said, bring your bakkie. Brought the bakkie. It wasn't enough. We had to hire a trailer. Some of us on the trailer, some of us in the back of the bakkie, driving slowly from Pritchard Street across the Queen Elizabeth Bridge, slowly, lest all our papers fly away. And we took it slowly, we brought it up here, and heaved a sigh of relief when we handed it all in. And then we sat there thinking, who were the judges? What were the judges going to wear? I remember sitting and writing the heads and thinking, what color gowns were they going to wear? And the office was all abuzz about what color gowns you were going to wear. And how were we to address you? We knew there was going to be something different. No, my lord, my lady. It had to be something different. So that occupied some of our minds, even though we knew we were doing something really important and big. And then, of course, I, personally, I felt I was part of history. I felt privileged, excited and nervous at the same time. I'd been to Bloemfontein, so I knew how it was. You walked quietly, you spoke quietly, thick red carpets, you whispered. Everybody knows. And the clerk comes to fetch you. Don't do anything, leave all your bags. Walk slowly to see the 5 judges. Here we didn't know. And I thought, I'm not even going. And what happened? We landed up in this building here. Nondescript, ugly building with lino on the floors. It was as though, when we got there, it was as though as lawyers, we knew we were doing something important. We had no time for pretty pictures on the wall and expensive carpet on the floors. We were here for an important job. And so it was drab. But lawyers, you know, we used to drab courtrooms. But anyway, we went there to change the law. And we did. It was an unassuming office. And anyway, we sat down before the 11 judges. One of my colleagues, and I'm sure he's not here, he says one of the memorable moments for him was what had happened was, Advocate von Leers had started arguing in the morning, and halfway through the morning, one of the judges said to him, do you know that there's a US state that has had the death penalty and has abolished it? And we, of course, didn't know about it. We had no idea. Von Leers was now screaming at all of us in the lunch adjournment. And he said, somebody had come from the office just to listen to it. And he said, you go off to the American Embassy right now and find out about this. And that person jumped up from the car and rushed away. And of course, quite coincidentally, there was a newspaper in the embassy quoting that very case. He brought it back, and of course, anybody who knows how von Leers was, with his usual flair, he said, here's the case you referred to. But of course, we knew we weren't going to win. But anyway, we were still a little disappointed because we knew we put a good fight. But of course, the Constitution stands, right to life, right to dignity, against cruel and inhuman treatment, all of that stands. And so, I'm glad I didn't have to talk of the judgment, just my memories. And I'm forever grateful for that opportunity, forever grateful for this opportunity. And even today, 30 years later, I am still in awe that a court such as this was created and convened and continues to protect the rights of all our citizens. On this 30th anniversary, my wish for the present and future Constitutional Court judges is that they continue their work and prevent the country from descending into chaos and remain guardians of the fundamental human rights of all South Africans.
Thank you very much to the two legal teams, and that brings us to the end of that segment of the session. We will immediately move to taking an address from Professor Sandra Liebenberg on socioeconomic rights and the reflection of 30 years of the jurisprudence of this court. Thanks.
Chief Justice Meyer, thank you so much for the invitation. It is such an honor to be here today on this momentous milestone in the court's history. So in the interest of time, and we all want to hear from the former Chief Justice as well, I had hoped to address 3 themes, but I'm going to just focus on 2 themes. Namely, just some reflections on the significance of having socioeconomic rights as justiciable rights in the South African Constitution, and then secondly, what I see to be the major impact of the court's jurisprudence and the model of review it has developed, and then a concluding sentence or 2. So firstly, the significance of including socioeconomic rights in the Constitution. This integration of civil, political, economic, social, and cultural rights was really a response to the realities of how the colonial and apartheid regimes operated their oppression. Political, social, economic, cultural repression were closely intertwined and mutually reinforcing. The denial of the right to vote of the black majority was accompanied by the dispossession of their land, the destruction of traditional livelihoods, and systemic discrimination in access to health care, food, water, education. Resistance was met by increased civil and political repression. So it is of course natural that when it came to drafting the Bill of Rights in the Constitution, that a holistic and integrated vision of human rights would be included in the Bill of Rights. And this was not only lip service to these rights, but these rights were given real teeth in the sense that, like the other rights in the Bill of Rights, the court was given a mandate to enforce these rights. And although the South African Constitution is certainly not the only global constitution to include socioeconomic rights, it is certainly a highly influential model, and it gives practical expression to the lived reality of the fact that without food, water, healthcare, decent education, those founding values of the Constitution, human dignity, equality, and freedom, will ring hollow. And here I borrow, of course, from the words of the late first president of the court, Arthur Chaskalson. Turning then to the impact of the court's jurisprudence and the model of review it has been developed. So while the recognition of the rights as justiciable rights was symbolically very important, the proof was going to be in the proverbial pudding. Would these rights, as some had predicted, simply amount to window dressing with no practical impact? Or would they impose unmanageable expectations on the court and drive the Constitutional Court into dictating legislative choices and making policy and budgetary priorities? Happily, none of these predictions has come to pass. The courts, under the leadership of the Apex Constitutional Court, has developed an impressive body of jurisprudence. I don't have time to go into all these cases. Some have been highlighted, but I just want to highlight a few developments. I think in the area of property and housing law, the Constitutional Court has developed a jurisprudence which has required an equitable balance between property rights and housing rights. And no more like the pre-constitutional common law is property law an absolute trump when faced with people who are literally landless and homeless. The courts have to find an equitable balance. The Grootboom case, of course, which was mentioned this morning, penned for a unanimous court by Justice Yacoub, led the way in this regard. But there are, of course, a whole series of other judgments in this trajectory. The celebrated Treatment Action Campaign case. Through this judgment, government was ordered to expand antiretroviral treatment to all women in the public healthcare sector giving birth to prevent mother-to-child transmission of HIV. The impact of this judgment was enormous because it broke a political logjam which resulted eventually in South Africa developing the largest HIV program in the world. The court has also developed the integral links between socio-economic rights and the right to equality. Thus, for example, it is held that non-citizens in the form of permanent residents who are excluded from social assistance have a right of access to social assistance in a beautiful judgment penned by the late, great Justice Mokgoro. In Mahlangu versus Minister of Labour, the court held that the exclusion of domestic workers from vital social security legislation and the Compensation for Occupational Injuries and Diseases Act was unconstitutional. There have also been a rich series of judgments on the right to education, building on the foundational judgment of the court in the Duma Mashid versus SA case, in which it was held that the right to basic education is an immediately enforceable right. I now turn to the second concern, that by enforcing socioeconomic rights, the courts would encroach on the terrain of the legislative and executive branches of government. This was a theme the acting Deputy Chief Justice addressed in his address. Instead, the court has developed a sophisticated model of review, the well-known reasonableness model of review, which enables the court to skillfully navigate separation of powers issues. By doing so, it places the primary burden of fulfilling socioeconomic rights on the legislature and the executive, the branches of government on whom this burden correctly rests, but preserving its own role to evaluate the reasonableness of their conduct. And in an incremental series of cases, the court has also developed criteria for assessing the reasonableness of state conduct. Thus, the court has held that a comprehensive, coordinated, and integrated program must be adopted to give effect to socio-economic rights. That program must include short-term measures of relief for people whose needs are urgent and who are living in intolerable conditions. The program should not contain unreasonable exclusions or restrictions. It must be flexible and responsive to scientific evidence and changing circumstances. It must be transparent and incorporate, where possible, meaningful engagement with the beneficiaries of the rights. This model has been highly influential internationally. It has influenced the drafting of the optional protocol to the UN's International Covenant on Economic, Social and Cultural Rights, drawing on the language of the reasonableness test. And it has influenced several other countries. However, Chief Justice and Program Director, I would not be an academic if I was not also allowed to voice a few tiny words of academic criticism, with all due respect for this model of review. I think it has many, many virtues, but one criticism that I and other academics have highlighted is that reasonableness cannot be assessed in a normative vacuum. If we are to judge whether the state is behaving reasonably, we must know what the end goal is. What does it mean to broadly say that people have access to adequate housing, healthcare, education, etc.? And one can develop the normative elements of these rights. Now, certainly there's plenty of international and comparative jurisprudence we can draw on, but I want to, in the few remaining minutes that remain to me, say that in recent jurisprudence of the court, I see the seeds of developing that normative content developing. Thus, for example, in the Daniels v. Scribante matter, the court, per Madlanga J, as he then was, adopted a purposive approach to the interpretation of the right of an occupier on a farm under the Extension of Security of Tenure Act to reside on the property in question. As the South Africans will know, ESTER is key legislation giving effect to the right to land and housing in the Constitution. The court held that the right of a farm worker, Ms. Daniels, to reside on the farm in question meant a right to reside in conditions that are consistent with human dignity, namely a habitable dwelling. And based on this interpretation, the court held that Ms. Daniels had the right to make modest improvements to her farm dwelling without the owner's consent. The second judgment I will highlight was a judgment handed down in December last year in Chanel Commando versus City of Cape Town. This judgment built on Justice Majid's minority judgment in Tubahali and others versus Ekurhuleni Metropolitan Municipality to recognize that the redress of the legacies of spatial apartheid in urban land and housing was a key normative goal of the housing rights in Section 26 of the Constitution. This led the court, per Matopo J, and in the partially dissenting judgment of Pilchards AJ, to recognize that location of housing in the South African context is a key element of the right to housing. And so through these judgments, we have three key normative elements of the right to housing recognized: that housing must be habitable, that it must offer security of tenure, and that it must be in a location that helps redress the legacy of our terrible history of group areas and urban consolidation legislation. So in conclusion, I believe that the court can be justifiably proud of its record in adjudicating socio-economic rights. The court is a major source of inspiration and hope, not only to us in South Africa, but I think globally, particularly at this moment when human rights are so under threat. Whilst we should celebrate the court's achievements, we are of course acutely aware, as the President reminded us this morning, of the deep patterns of poverty, economic inequality, gender inequality in South African society. These challenges are, of course, for the elected branches of government and all of us in society to address. But the court has a critically important role in holding the state accountable for those rights that speak most directly to the scourge of poverty and inequality. In fulfilling this role, the court is not undermining democracy, but rather holding the state true to the foundational commitments and values on which our constitutional democracy was founded. Long may the court continue to perform this role. I thank you.
Thank you, Professor Liebenberg. Even our invited guests are guaranteed freedom of expression, and we take the criticism in the spirit in which it's offered. So that brings us to an end to this session. Can you please give the participants a round of applause? Thank you. Please invite former Chief Justice. The former Chief Justice needs no introduction, but it would be impolite for me just to tell him to come to the podium. So it's really an honor for us to have the penultimate speaker being the former Chief Justice, who will share some with us in the 15 minutes he's been allocated. Some reflections of his time here.
I think Justice Colopin thought that I was taking over as both program director and speaker when I came straight here. I thought that when he moved aside, he was moving aside for me. Chief Justice Mandisa Maya, Chief Justice Mandisa Muriel, Maya, all the Chief Justices who have attended this gathering from all over the continent and beyond the oceans, and former Deputy Chief Justice of the Republic, Justice Musenege, and justices of the Constitutional Court in previous years, and I should have mentioned Upungane Elia, Acting Deputy Chief Justice Madlanga. I'm going to take out my wristwatch and put it in front of me so that I can see when I am about to go beyond the time. Before I say something, I just want to say something about an announcement that the President made this morning about the institutional independence of the judiciary. He made a profoundly important announcement for which we have been fighting for and waiting for as the judiciary for many years. Chief Justice, the previous Chief Justices, those who have departed and those still alive, I am sure would have been very happy to hear it. And those who are alive, if they did hear it, would be very happy. Chief Justice Ngobo played a very critical role in the fight for this institutional independence. Chief Justice Mkhweng did the same. I played my part. But I want to congratulate Chief Justice Maya for having been able to ultimately extract the commitment from the executive. I take this opportunity to express my gratitude and appreciation to Chief Justice Maya and her team for inviting me not only to attend this historical celebration of 30 years since the Constitutional Court opened its doors to the public in 1995, but also for inviting me to share with you some thoughts on the successes and challenges in running an apex court. I've no doubt that the reason why I was assigned this topic was the fact that I am the immediate past head of this court. I wish to congratulate Chief Justice Maya and all her colleagues on the Constitutional Court, my former colleagues, for the most befitting decision they took to bring us together today in the fashion in which they have brought us to celebrate 3 decades of this marvelous institution that has played such a pivotal role in protecting, promoting, and defending our constitutional democracy in general and the rule of law in particular. Congratulations, Chief Justice Maya and your colleagues. Well done. The topic suggests talking about running the successes and challenges of running an apex court. But I think the fact that it refers to successes and challenges can only mean that I must talk about the only court that, apex court that I ran. I've only run one apex court. Therefore, it would be more beneficial if within the limited time I were to share with you my thoughts on some, though not all, the challenges and successes of South Africa's Constitutional Court when I ran it. I hope that sharing my thoughts with you may enrich your understanding of what challenges some apex courts face and how they go about trying to address those challenges. However, before I share my thoughts, I need to point out that as I was not coming in as the first head of this court, I built upon the foundations and work that was done by all those who came before me. In this regard, I acknowledge the enormous contributions that were made by Chief Justice Arthur Chaskalson, the first head of this court, Chief Justice Pius Langa, the second head of this court, Chief Justice Sandile Ngobo, and Chief Justice Mkhweng. But I also must hasten to acknowledge the enormous contribution that was made by all the justices who have served in the Constitutional Court from what I call the first team, that is the team of the first justices of the Constitutional Court, who laid an enormous foundation for the jurisprudence that we have built on. An apex court, like any other court, is run by the head of that court, However, it is important to acknowledge that the head of any court does not run a court alone. He or she does so with the assistance of his or her colleagues, as well as the office of the registrar and other personnel in the office. The same applies to an apex court. In my case, I owe a great deal of appreciation to my colleagues, as well as the court manager and all personnel in the registrar's office, and the support from the office of the Chief Justice for the absolute support and cooperation they gave me during my term in running South Africa's apex court. When I began to run the Constitutional Court as acting Chief Justice in July 2021, having been Deputy Chief Justice since 2017, I was aware of the challenges that the court had, which impacted negatively on its performance. The time does not allow me to deal with many challenges, and therefore I've chosen only a few. I mentioned in passing that one of the challenges that the court had from the beginning of its life was the question of defining with any precision what a constitutional issue is, which went to its jurisdiction, and we know that over many years that remained a difficult issue which caused uncertainty on jurisdiction. Another issue which I think was also a challenge, which I won't go into in this address, was the issue of the jurisdiction of the Labour Court vis-à-vis the jurisdiction of the High Court in relation to labour matters or administrative matters. For many years, that remained a contested area, and I do not think that, I think that despite the progress that has been made, it might be that the last word has not been said. Nevertheless, for purposes of this address, the challenges that I would like to mention are only three. The one was there were serious delays in disposing of new applications, that is A. B, there were delays in the handing down of judgments, and C, the court was facing a challenge in attracting enough suitable candidates to fill judicial vacancies on the court, which led to the court functioning most of the time without a full complement of justices or frequently with a high number of acting justices. I shall talk about A and B together because they are related. That is, delays in disposing of new applications and delays in handing down judgments. In seeking to tackle these challenges, I engaged my colleagues as any head of an apex court would, if he or she hoped to ensure that whatever changes he or she wished to bring about had the support of his or her colleagues. My colleagues and I sought to determine what was causing these two problems. One of the conclusions we reached was that the expansion of the jurisdiction of the Constitutional Court in 2013 to include non-constitutional matters had substantially increased the caseload for the court in circumstances where the number of judges adjudicating them remained the same, namely 11, but sometimes 10. It is quite clear that if there is a serious increase in the workload in any court, there should either be an increase in the number of judges doing the cases in order to cope with the increased workload, or some other way should be found to deal with the problem. My colleagues and I did not think that an increase in the number of justices, which would have required an amendment of the Constitution, would be a viable solution. We had to try and identify a viable solution that did not involve an increase in the number of justices. We concluded that we needed to enhance our sifting mechanisms. That is, the process of sifting new matters that would be heard by the justices and matters that would not be entertained. It seemed to me that the Constitutional Court had, over the past 30 years, built up a very good track record as a court that performed its functions without fear, favor, or prejudice. And as a result of that, the populace had confidence in it, and that is why almost everybody wanted their case to end in the Constitutional Court if they had lost. We decided that although the law clerks that support the justices of the Constitutional Court render an important service and do a very good job, it would be necessary to beef up the support service to the justices by the appointment or employment of experienced lawyers who would provide another layer of personnel support to the justices. We considered this necessary because the law clerks were or are all the time recently graduated law students without much experience, but as I've said, who are very helpful at the court and make a very serious contribution. Apart from doing their research for justices, the law clerks prepare memoranda for justices on new applications, but the justices end up spending quite some time on new applications, memoranda involved in the, and they get involved in the preparation of memoranda before they are circulated to their colleagues. We were of the view that when one looks around the world at other apex courts, one sees that it is quite a common phenomenon to have experienced lawyers giving support, a support service to justices, to apex courts. We then took the view that the introduction of a layer of experienced lawyers in the provision of a support service to the justices would not on its own be enough to solve this challenge of the court. We took the view that what was also critically important was to reduce the number of new applications that each justice needed to deal with, In 2023, the court received more than 350 new applications. That meant that each justice of the Constitutional Court had to read all those more than 350 new applications in order to take part in their adjudication. That is because in terms of the Constitution, except in a situation where there is justification for less than 11 justices to adjudicate a new application, every justice of the court would have to take part in the adjudication of all those new applications. We thought that there was actually no justification for all the justices, 11 justices, to participate in the disposal of every new application. We decided that the best scenario would be that the Constitution should be amended so as to allow panels of 3 justices to dispose of new applications, because if that were to be done, that would mean that if there were 350 new applications to be disposed of, the position would no longer be that every justice would have to take part in the adjudication of, for example, more than 350 new applications that were lodged in 2023. This would make a substantial reduction in the workload of the justices. Did this mean that the court would do away with sitting and bank? No, we said. For those matters that would be set down for hearings, the court would still continue to sit and bank. We made this proposal and called upon the public and organizations to support this proposed amendment to the Constitution in order to enhance the efficiency and effectiveness in the running of the Apex Court of South Africa. That proposal was also made to the executive. We wait for their response. So what we did, therefore, was to look at 2 possible changes. One was the introduction of more experienced lawyers who would work together with the law clerks to give assistance to the justices. 2, amend the Constitution so that 3 panels of 3 justices, for example, could sit to dispose of new applications. But in the end, any matter that was decided as deserving of a hearing would end up being before the full complement of 11 justices. Those are the 2 changes that we proposed, and we hope that they will work. I want to, because of time, to immediately go and talk about successes. There are many successes of the Constitutional Court of South Africa. But the one thing that I want to raise is We have, at the end of a period as long as 30 years, to look back, and where an organization such as this has been as successful as the Constitutional Court of South Africa has been, ask the question, what is it that has made it so successful? Because for the next 30 years, we need to make sure that that which is responsible for its success is continued. But we must also identify what it is that hasn't worked and what it is that has impeded maybe greater success that this court would have achieved. Because then, once we identify those, we need to make sure that beyond these first 8 years, we do not continue with those things. Because the success that this Constitutional Court has achieved in the first 8 years must be a much greater success when we reach the next 30 years. Therefore, the only way to do that is to look at what works and what is responsible for our success. In my view, if one looks at the success of the Constitutional Court, one is driven through the fact that it enjoys a lot of the confidence of the people of South Africa. That is why it is inundated with so many cases, because everybody wants their case to end in the Constitutional Court. Now, as an institution, you don't earn that trust and that confidence lightly. So the question arises, why do you think the people of South Africa respect the Constitutional Court as much as they do? Why do they have the kind of confidence they have in it? My answer is that it's because its greatest success has been its jurisprudence. The greatest success of this Constitutional Court has been its jurisprudence. But above all, I think it is because it has built a track record in terms of which its justices, from the first ones of 94 up to now, perform their duties in accordance with their oath of office. They administer justice without fear, without favor, and without prejudice. Many attacks have been directed at the Constitutional Court and the judiciary in general in South Africa. But in the end, nobody of those who attack it is able to produce any evidence to support their attacks. When I was chairperson of the State Capture Commission, I called on anybody who had evidence of corruption against any judge, because there were those who were making noise that judges were pressured. Not a single one came up with evidence. Even now, those who make those attacks do not have evidence. As long as the court is seen by the people as being able to make its judgments without fear, without favor, and without prejudice, the citizens will have confidence. And we know many cases where the Constitutional Court has shown that it is fearless. A reference has been made, I think earlier this morning, to judgments of the Constitutional Court which have upheld the constitutional principle that we are all equal before the law. Whether you are rich, whether you're the most powerful person, whether you have millions of supporters, if you come before the Constitutional Court, and that applies to other courts, but the Constitutional Court as the apex court has to lead, you are equal before the law with anybody else. And what would be done to anybody else would be done to you. And I believe that the current justices will continue on that path. And I believe that justices who will be honored and privileged to serve on the Constitutional Court in the future will continue on that path. And whatever attacks may come their way, they will focus on their work, and their work is what will speak for them. So, in the interest of time, I would like to, in conclusion, I would like to say, I have no doubt in my mind that despite whatever challenges that this court may face in the future, I believe that it will grow stronger and stronger and will continue to be the uppermost guardian of our Constitution and therefore of our constitutional democracy. And that when we meet again here in 20 years' time, when it will celebrate 50 years of its existence, and I think I'll be there, we will be able to look back with pride at how it will have continued to protect our constitutional democracy. May it grow stronger and stronger every day. Thank you very much.
I think we should all thank former Chief Justice Zondo for once again in a powerful way reminding us of what this project is about and what our individual and collective roles. If we ever needed a reminder, it's here again. So it's been a long day. We got here when the sun was shining and the sun is now set, but the sun will never set on such a beautiful day, ever. So all that remains for me is to welcome once again the Chief Justice to the podium, to thank you and to perhaps, I don't know, say other nice things to you as she is wont to do. Chief Justice.
After the kind of day we have had, I'm going to address you simply as friends. And what a day it's been. As we conclude our program after a long but beautiful day, I wish to once more extend a heartfelt thank you on behalf of the South African Judiciary, including the Constitutional Court, to all of you present here today for joining us. Your presence has made this historic milestone truly special, and we deeply appreciate your contribution to these celebrations. To our international guests and speakers, we thank you for your solidarity and valuable contributions that have enriched today's program. The thought-provoking speeches delivered today did not only shed light on the Constitutional Court's profound impact on our young democracy and society, and other courts beyond the South African borders, as we heard. It also underscored the global significance of constitutionalism and human rights. Your insights have added depth and valuable perspectives to our celebrations, highlighting the court's pivotal role in transforming a broken society and advancing the rule of law. We are honored to have had an opportunity to learn from you and engage in discussions that will continue to shape our collective pursuit of a more just and equitable world. Indeed, while a lot of progress has been made, today's events mark a new chapter in our ongoing efforts to create a bright future for everyone in our communities. I want to take this moment to thank the representatives of the families of the colleagues in the first panel of the justices of the court, the Constitutional Court, the members of the South African judiciary, magistrates and judges who have come from all corners of the country, and indeed everyone who joined us today. Earlier, I thanked ADCJ Madlanga and his team for the wonderful job they did in helping set up this event. And I did that for the benefit of those who I knew would not be with us for the rest of the day, so that they know who was responsible for all this. But there are other parties that we need to thank, organizations that must be mentioned for the supportive role they played in ensuring the success of this event. And we thank each employee representing these state organs, the Department of Justice and Constitutional Development, the State Security Agency, the Department of International Relations and Cooperation, Constitutional Hill Development Company and its service providers, all the security structures represented in the Johannesburg City Joint Operations Committee, the Johannesburg Metropolitan Police Department, Emergency Medical Services, National Traffic Police, and all other organs of state, and our valued stakeholders, which I may have inadvertently not mentioned. We deeply value your contribution. I also want to mention just two last but very important matters. I would like to urge the former justices of the Constitutional Court to not wait until we invite them to the next big event that the court celebrates before they drop in. Please visit us. It encourages us to do better when we interact with you. Come in and give us a kind of chat that former DCJ, Mr. Neke, Justice Kate Oregon, and Justice Andrew Sachs had with us earlier today. Remind us about the values and traditions of this court so that we stay on the straight and narrow. The clerks love your visits. We also appreciate them as the justices. I also want to thank the citizens of the Republic of South Africa for joining this proceedings today via social media and via other broadcasting media. We are heartened by your support for the judiciary. Please be assured that we will continue to uphold the values espoused in our beloved Constitution, doing so in the interest, your interest, the public we serve. Lastly, I just want to assure everyone that while I may be no other justice or Raymond Zondo or any of my predecessors, but Mandisa Maya, during the time I have left in the court, it may not be 10 years, Mr. Dubato, something wrong with the arithmetic. But during this time that I have left in the Constitutional Court, this court, and indeed the entire judiciary, will remain unwavering in its resolve to deliver justice without fear, favor, or prejudice. With the same integrity that has been the hallmark of the Constitutional Court since its inception. Thank you once more, everyone, and travel home safely. Thank you.